What is up? And welcome back. Hope you all had a nice little break because we're about to get into some closings. Yeah, that's the good stuff right there. Yeah, I had a very, you call it unfulfilling break. I was hoping to drop some dry cleaning off. Was really hoping that Allie had ordered breakfast for us. Said she did, and then it didn't happen, and whatever. So I ate a I guess I consider it to be a suspect banana. It was definitely a little overripe. It was just a little bit overripe. Had a lot of brown spotting on it's the kind of banana that would be good for a smoothie, not so great for uh yeah, Countryside Fire Protection District. That's my son's firehouse. Dude's a hero. Dude's a hero. All right, let's pull this up. They should be coming back. Couldn't be more proud of my son. It's a very, very, very heroic young man. All right, let's pull it up. See what we got going. Should be popping. We should go right into closings. And remember, the way that closings work in most states, including Illinois and also Florida, is it goes state, defense, state for the rebuttal closing. So state gets the last word. It's their burden. Makes sense. Makes sense. Yeah, like over lunch, I was certainly sitting here thinking about, man, dude, it's like, how are you going to sit there and get a self defense instruction when she's denying that she killed him? I don't get that. Like, I'm so confused by it. So confused by it. Really am. Let me get up to time, up to speed. All right, so we're live. It's just weird. It's a weird instruction to give. It's a weird instruction, considering that they just didn't put anything even remotely close to that in terms of a defense. Um, Wait, Sinead, what you got? Did I hear your replay right? Evening show that will include us Europeans. Are you talking about tonight? I was thinking about doing a live tonight, but I got a better offer. I'm gonna go see Goose at the Salt Shed with my buddy. So no live tonight. Plus, to be honest with you, after 6 hours, 7, 8 hours, 9 hours of living, no one needs to see me on another live. You know what I mean? That's a lot of Mata. It's too much Mata, I would say. So no one needs that. You know what I mean? No one needs that. However, what I might do is the rare Saturday live. I try not to work on the weekends as much as humanly possible, but there's a lot of Delphi stuff that needs to be discussed. I have to continue to try to counter the torch and pitchfork crew that exists out there, which you know, um, it's a couple of them in particular that I feel obligated to try to counter them to even the scales of justice, as it were. Pre-trial. Let's quit judging before trials. Let's quit acting like we know what happened in cases when you weren't there. So, oh, Missy, you're the sweetest. You're the sweetest. Uh, yeah, I don't care about that. Like, I don't. Megan and I could care less about that. When you get hate, that means that you're making an impact. That's what that tells you. If you don't have people hating you, you ain't doing something right. So when I get the messages like, oh, Bob, it's like when Jay and I do the fan mail, when I'm like, oh, well, uh, you changed my opinion on defense attorneys completely. I'm like, that's amazing. It's exactly why I got into this. That's why, coming into the podcast, I had a million different directions I could have gone in. And I had to lean into what I felt was a huge gaping hole in the true crime community, and I felt that most people that consume true crime are completely misinformed about what defense attorneys do and what they mean to the system. It's like it's easy to sit here watching trials. I hate that defense lawyer. It's like you lose the scope of the bigger picture of why defense attorneys are absolutely critical to us as the systems, because you're watching it at a micro level as opposed to thinking about what we mean to us as a society at a macro level, and that's where the difference is. Like this guy, he's fine. I mean, he's moderately annoying, but he's got a job to do. Like, you can't spite somebody for doing their job. Every single lawyer puts their hand up, stands in front of a judge, and we all take the same exact oath. Prosecutors, defenders, our job is to uphold and defend the Constitution, and we are to zealously represent our clients. Period. It's non-negotiable. So, anytime that you have a lawyer that's really getting on your nerves as a defense attorney, I can almost guarantee you that lawyer is doing his job. Like probably the most annoying aspect of, like, if you're on a case as a defense attorney and you have a very, very strong inclination that you are going to lose, you better make goddamn sure, sorry to blaspheme for all you religious folks out there, that you are preserving the appellate record. And I've told you guys a million times, objections are what does that. You have to make objections. The fact that Hank Hill keeps, restating his motion for a directed finding at every stage. He did it after the state's case in chief was rested. He did it after he rested his case in chief. He did it after rebuttal closing, and he'll do it again. He'll do it again, probably after closing arguments by both sides. He's got to make an appellate record. That's how the system works. If you don't make an appellate record, you waive the issue for appeal. So, and like it or not, and trust me, like, we do not want to live in a country where no one can appeal their case. That's a little too definitive. No one would want to live in that country. I assure you of that. And if you have doubts about just how many crooked, frame up, shitty cops and prosecutors are out there, just start watching my Guevara stuff. It's up to 47 exonerees of one cop who put 57 innocent men and women in prison on murder charges. Different people who all served decades.
Back on the record in case number 2020
CF2361. All right, let's go.
Are there any preliminary matters, or can we call the jury?
I just have the corrected copy of the verdict form for you, given it to.
Yes, sir. Please approach.
I made the typo changes as well as replacing your packet.
Thank you, sir. Appreciate that.
We reviewed them, Judge, have no objection to them.
All right. Anything further?
Yes, sir.
All right, then we'll call in the jury.
You will bring the jury. You will bring the jury. You will bring the jury.
Oh, Jesus.
Oh, thanks. Thanks, Shana. Yeah, no, that's exonerated, Blair. 57 innocent men, primarily men, and one woman who actually was on death row, all being framed up by the same cop and his crew of misfits. Yeah, Chicago is going to be paying to the tune of $1 billion with a B, billion dollars out on wrongful convictions because of this cop who's walking around getting his pension down in Texas. Reynaldo
All right,
Rivera.
thank you. Thank you again. I see that all of the members of the jury have returned, and thank you again for your time and attention today. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, you may proceed.
May I please report?
Yes, sir.
On November 7th, 2015, Michael Shaver went with his family to meet up with some friends at a tractor show. This is the last time Michael Shaver is ever seen by anyone other than the woman that murdered him, Laurie Shaver. You've heard a lot of testimony and evidence over this last week discussing Facebook, phone records, bank records, all sorts of evidence for your consideration. But it's important to remember that why we are here is because Michael Shaver was shot in the back of his head without any sort of legal excuse or justification and buried in his backyard. Michael Shaver, between November 7th and November 10th, shot in the back of the head and dumped, wrapped in a tarp in his backyard. That's what we've been here this week. That is what the evidence has shown you. And it has shown that the person who did that is Laurie Shaver. The elements of second-degree murder are fairly simple. And it is these elements that the state must prove beyond a reasonable doubt. You can have doubt in this case. You can have doubt in any criminal case. State's burden is to prove this case beyond a reasonable doubt. These three elements. And that is what we must prove to you. First, Michael Shaver is dead. 2, the death was caused by the criminal act of Laurie Shaver. 3, there was an unlawful killing of Michael Shaver by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. That third element is further defined by the court as an action that is reasonably likely to kill. A gun to the back of the head is obviously something reasonably likely to kill. Done with ill will, hatred, and spite. I can think of no other reason in a person's mind when they're shooting someone in the back of the head other than those three things. And 3, indicates an indifference to human life. The evidence that you have heard throughout this trial clearly show that that first element and the third element are really just not in dispute. What we are going to spend the majority of time talking about this afternoon is whether or not the death was caused by a criminal act of Laurie Shaver. And the evidence that you have heard shows that the state has met its burden for that element. As you heard the judge give you the instructions already, there is something that is called a lesser included offense to this second-degree murder, and that is manslaughter. The difference between manslaughter and the second-degree murder is it does not have that third element about an act done imminently dangerous, demonstrating a depraved mind without regard for human life. So if you feel that the state has proven that Laurie Shaver is in fact the one that shot, but didn't have that state of mind at the time she shot him in the back of the head, manslaughter would be the offense that the state has proven in this case. As we go through the evidence, I want to remind you of something that Mr. Wiggs said in his opening statement. And what said in opening statement is not evidence. If you've heard some things in opening statement that was going to be presented to you and it came out differently. What you heard from that stand, what you got from the evidence sitting on that table over there, that's what you are to consider, not what the attorneys talked about in opening. But what Mr. Wiggs said is you aren't going to hear just find her guilty because common sense. But the instructions that the judge gives you, and the judge will give you a full written packet of all of these instructions. So you don't have to worry about writing down the various instructions as we're talking about them. The judge will give that to you. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. So common sense is absolutely part of the instructions the judge is giving you and absolutely part of what you should use when you are weighing the credibility of the evidence, the witnesses that have testified from both sides. The state has proven this case through the totality of the circumstances of this entire investigation. It is important to remember that Laurie Shaver is the only one that stood any sort of benefit to gain by the death of her husband. She had the means, the motive, and the opportunity to do this. And when I talk about the means, the gun that was recovered from Robert Seha that he purchased from Laurie Shaver prior to the body being discovered is the same caliber and class as the projectile found in Michael Shaver's skull. And remember the testimony of Megan Cleek, the firearms investigator from the Florida Department of Law Enforcement that did that analysis. Once again, I'm going to trust that you remember what she said as opposed to what the attorneys say about it. But what she said was the projectile that was found in the skull was the same caliber, meaning that it was the right size ammunition to be fired from that pink and black 38 special. She also said that it had all of the class characteristics from that type of firearm. The only thing she said it was missing in order to make a full comparison and the thing that she would need in order to say, in fact, it was that gun, is it didn't have enough evidence of the individual characteristics from that firearm. You saw the condition of that projectile, how smushed it got once it struck the inside of the skull. You also heard her say when she did the test fires with that weapon in the most pristine situation she possibly could, firing into that water tank, the individual characteristics that were left on those pristine projectiles were very hard to see. So between the time frame, the degradation, and the fact that this gun does not leave strong individual characteristics, it's completely understandable why 4 years later, when it's examined, they just can't find it. But all of the evidence that is in that projectile is consistent with being fired from that weapon. Motive. We actually heard evidence of a couple different motives because it is clear that she wanted to be with Jeremy Townsend. We are going to talk much more at length about the Facebook activity, the flowers, the messages sent to Vanessa Townsend, but she wanted out and she wanted to be with her new boyfriend. But you also heard her say when Frank Merritt came to check on the whereabouts of Michael Shaver, when she claimed that he, in the middle of the night, got into a black SUV, abandoned all of his property, his vehicle, his clothes, anything that had any sort of value, and hauled up to Georgia, that she and Michael had a fight because she found the fact that his previous girlfriend, Kendall Davidowski's phone number was still in his phone. Motive is not something the state has to prove beyond a reasonable doubt. It is not one of those elements. But we have presented you evidence of what her motives would be in this case. And finally, opportunity. That means, was this person in a position to commit this crime? I believe Detective Dale summarized it best when she said, the body was found buried in the backyard. It's not like he got carjacked and shot on I-Drive. All three of those factors point in the direction of Laurie Shaver. So now let's talk and focus on the totality of circumstances. That goes to all of that on that table, all the things that have been presented to you, showing how she hijacked his Facebook, showing how she impersonated him to his friends and family members through texts, Facebook messages, took all the efforts she possibly could to avoid anyone from starting to look. Now, you have heard various friends and family members talk about how over the course of 2.5, 3 years, they went looking for Michael. It wasn't a scenario where he talked to anybody on a daily basis, weekly basis. There were times that he would go and not visit and things of that. But he always responded. When people would reach out to him, he would respond. He wouldn't leave those messages unanswered. And when they did get any response after November 2015, every single person that talked to you about that said it was obviously different. It was not the way he would respond. Finally, when taking all of the circumstances, all of the evidence, and putting it all together, that's where the state is asking you to rely on your common sense. Because you can take any one piece of this puzzle and you can look at that and you can say, well, I mean, that's not an eyewitness that saw what happened. That's not a piece of DNA. Maybe that's not something that proves in and of itself that Laurie Shaver committed this murder. And we're not saying any one piece of evidence over there does that. We never have. We got up here, Mr. Buxman in opening was straightforward with what you were going to see. He told you there's not going to be a witness that's going to say Laurie Shaver did this, that I saw her do this. He told you what the forensic evidence was going to be. We put that up there so you could see it. But we also gave you the explanation of why, after someone is buried in the ground over multiple years and their body decomposes, the effects that that has on any sort of trace DNA evidence, any sort of trace fingerprint evidence. But we were upfront about that with you. We told you that's how it was going to be. But we are asking you to follow that judge's instruction and use your common sense in looking at all of this together. Because when you look at it all together, the conclusion is crystal clear. Let's start going through the timeline. November 7th, 2015 is the last time Michael Shaver is seen by any friends, family members, co-workers, anyone other than Laurie Shaver. November 9th, 2015, after Frank Merritt had reached out first to Michael the day before, text about a gun cleaning kit, did not get any response. He followed up with that. And Michael says, well, I put air quotes, Michael says to Frank Merritt, have to quit my job to work on my marriage. Submit to you, someone going and becoming unemployed and not earning any money probably isn't the best way to go about working on and contributing to the marriage. But that's the first type of response that people thought was odd. November 10th, 2015 was the first time ever that Michael Shaver did not show to work and did not call to say he was not coming in. This continues to November 12th, 2015, and ultimately leads to his termination. November 11th, from those Facebook records, the Laurie Shaver Facebook records, Laurie Shaver posts a public posting to the entire world wishing various veterans a happy Veterans Day. Most importantly, in that list of people that she thanks is her brave, loving man. Michael Shaver was never in the military. Her husband was never in the military. Jeremy Townsend was. One day after Michael Shaver has no contact with his place of employment, she is publicly posting for all the world to see, talking about her brave, loving man, veteran, Jeremy Townsend. November 12th, 2015, John Borglum receives a text message from Mike's phone that's saying he has issues at home and was in Georgia, so go ahead and fire him. Now remember, there's absolutely no evidence whatsoever that he was ever in Georgia. None of his bank records show any activity up there. His family members in Georgia, they haven't seen him. And Mike just leaves his job, his vehicle, everything behind. November 13th, 2015, because this is all extremely unusual, Frank Merritt goes to the Shaver residence to check in on Mike and is told he went to Georgia. Now, when Laurie testified yesterday, she tried to say, oh no, he must have misunderstood. I never said Georgia, definitely. That's just a misunderstanding. But remember, he's not the only one to say he got a message about Mike going to Georgia. John Borglum the day before, in that text message sent from Michael Shaver's phone, and whoever had that said he went to Georgia. Laurie's version of what happened in November. She kicks Michael Shaver out after the November 7th, 2015 tractor show, and he returns to live at the airplane hangar. So now the story has changed from he went in a black SUV, went out in the middle of the night to go up to Georgia, to he is living at the airplane hangar. If that is true, you need to believe all of the following. One, despite the fact that the last time he was out of the home and living at the hangar, he was still working at Disney, he somehow decides to abandon his source of income. He's kicked out of the home. He's obviously going to need a place to stay. He's going to have to pay for bills, pay for food. But that's the period of time he decides, I'm not coming to work anymore. You also have to believe that he decided to just abandon his vehicle, his source of transportation, his source of actually maybe finding another job, being able to go various places. You also have to believe that he leaves behind anything he has that has any sort of value. Guns, tools at Disney, anything. Now he's unemployed, homeless, gonna need to fend for himself, but he just leaves all of that behind. And then you heard also today from Katina, they left all of his belongings, toiletries, and clothing behind at the house. So you basically have to believe, if you believe Laurie Shaver's version as she told you yesterday, all of those things would have to be true. So what's the evidence that that's not true? Well, the person that she indicated took him to Georgia came in and said, nope, I didn't do that. All of his friends, all of his family members that live in Georgia, no, we never saw him. All of the bank activity is here in Claremont by the home that he lived in with Laurie. The bank activity is not even out by the hangars. There's one entry that deals with Disney, but every ATM withdrawal, Groveland, Claremont, 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 Claremont. He was not in Georgia. No outgoing phone activity after November 7th, 2015. None. And then, if he is kicked out of the home, fending for himself, there is absolutely no reason for him to just also cut off contact with friends, family, and coworkers. But that's exactly what happened. Michael Shaver was dead before November 10th, 2015, because he fell off the face of the earth. There is no bank, phone, any activity that is associated in this day and age with what people need to do in order to survive, because he's dead. These are the various records that you heard about, that you saw. Everything is in those folders so you can review it. But this is what I am talking about the bank activity from the time he was killed before November 10th, 2015, and then December 30th, when that account just becomes overdrawn and is never used again. November 20th, online purchase to wish.com. November 24th, online purchase to wish.com. 12/14, ATM deposit. What was that deposit? That was the check that was mailed to his home from Mariner Finance. And this is important because this check was sent to the place where she lives. And it was deposited in Claremont. Michael Shaver does not have a vehicle. I think Laurie was trying to explain to you how, well, he would just come by, no one would see him, no one would know anything, but he would just check his mail because it was out by the street. That makes no sense. He has no car, he has no money, no phone, but he's coming by to check his mail and get this check? No. That's just not credible. That's not believable. He then, after he makes this deposit, ATM withdrawal Appellate, 12/14, ATM withdrawal Claremont, 12/18, ATM withdrawal Claremont, 12/21, ATM withdrawal Groveland, 12/21, ATM withdrawal Claremont, 12/23, purchase from Walmart.com. Who was the purchaser there? She was. You saw the receipts. You saw the Walmart.com records. You saw it went to that address. Finally, 12/23, ATM withdrawal Claremont. And at that point, on the 30th, the account becomes overdrawn, never used again. Mike is walking around, having no contact with friends, family members between November and May. We're just getting his money. His bank account is cashed out, absolutely no activity. There's no reason, if he's out trying to forge for himself now, kicked out of the home, living at the hangar, he doesn't maintain his bank records, bank accounts, but it is depleted by Laurie. All of that activity is Claremont and Groveland. Phones. This is Michael Shaver's phone records. This is the number that he had. This is the number that you heard his friend Brendan Burns actually pull out his phone, say, I still have his phone number programmed in my phone. This is what it is. This is that 5121 number. And once again, all of these records are in those folders. You can look at them yourself. And obviously, you can't read all the detail here. But the point of putting this up was to show you that this one in blue is that phone call he made out on the 7th to Epcot. That was the Detective Dale told you. That was the last outgoing call from this phone number. In the research, that phone number was associated with a landline in Epcot, where he worked. Before that, this is all the activity. It almost daily calls out, calls in, calls out, calls in. This first area, all those yellow highlighted, are calls back and forth between him and Laurie Shaver. After November 7th, nothing. Not a single call out from his phone. He doesn't have a car. He doesn't have a job. He's not at the hangar. None of his friends there have seen him. He's got to communicate with somebody if he's alive in order to keep going. But there's no activity because he's not alive, because Laurie Shaver killed him before November 10th, 2015. The only phone record after November 7th, 2015 is the collections call from Mariner, because the check that was mailed to her was deposited in Claremont and they were coming to collect. And when they called, remember what Tara Mitchell told you. A female answered the phone and said, oh, this is a new number. But we know that's not true, because you have all the phone records showing the history of that phone number, and how it changed. And we'll come back to that. So let's keep going with the timeline. In December of 2015, Mike's mother becomes ill. His family is seeking him out to let him know that she is very sick. I believe the testimony from Stacy Turner was it looked like she might not make it. Couldn't get in touch with him. All the texts, phone, Facebook, whatever they tried, couldn't find him. He's dead. But they did get in touch with Laurie. And she said, I'll get word to him. No phone calls to him. She knew she didn't have to call him. She knew he was dead. Because she killed him. March 24th, 2016, Laurie Shaver posts about the fire pit that she made. This is the area that multiple witnesses told you was a hole, was going to be a duck pond. But now in March 2014, that area is filled in. And wouldn't you know it, Michael Shaver's right there. He's in that. Isabel described it as a really big hole. April 6, 2016. This is where we start showing you how we know Laurie Shaver had Michael Shaver's phone and access to the ability to text people, had access to his Facebook, had access to everything she needed to do to keep people from starting to look for him, to keep people from investigating the fact that she killed her husband and buried him in the backyard. That phone number, 352-431-5121, on April 6, 2016, this would be approximately 4.5 months since Laurie said, I kicked him out. But that phone number is changed. Saw those records, Vice brought in, changed phone number to 352-801-0941. And then 10 days later, that phone number is changed again to 352-431-8444. As a reminder, the phone numbers that were important in this case started off with the 431-5121 number, the one we just talked about, how it got changed 2 times within the period of 15 days. We know that was Mike's number. The records are connected with Laurie Shaver as the subscriber. We also heard Brendan Burns testify. That was the phone number I've had programmed in my phone since the last time I ever talked to my friend. Laurie Shaver's phone is 352-431-0419. We have our phone records. We have the screenshot from the time frame that Vanessa Townsend had reached out to Laurie to discuss the messages that she had received. We also had the screenshots from the text messages between Jeremy Townsend and Laurie Shaver, and lo and behold, the phone number associated with Laurie Shaver in those text messages is this 431-0419 number. Now, Laurie testified yesterday and doesn't seem to remember any phone numbers that she's ever had, but the records show it, the screenshots show it, the text messages show that was her number at the time. And then there's a folder that, as opposed to the call details and said this is the call out, this is the call in, that third folder we talked about with Tanner Gale shows the history of that phone number and device. And it shows how on April 6th, the phone number was changed from Mike's original number to the 0941 number. Why is that important? Well, 2 days later, after changing Michael Shaver's phone number to a new number, she reaches out through Facebook to contact Vanessa Townsend and says, here is my number, call me. Vanessa Townsend goes to call that number at one point. Remember what she said. I called this person and asked me to call them. They wouldn't answer, but they would text. Or you can't answer the phone and pretend she's Mike anymore. She has to text. Well, that number only stays in place for 10 days. She got it. She did what she needed with it. She got rid of that number, got a new number. What number was that? 352-431-8444. Why is that important? Well, in July, she's filing a court document with her address and her phone number, 352-431-8444. This shows that she had the original Mike Shaver phone and phone number this entire time. This shows the constant link between when she killed him in November, had his device, had the number changed to contact Vanessa, and then had it changed again to the number that she represented as hers. April 6, 2016. Laurie Shaver's bank records reflect the purchase of flowers sent to Vanessa Townsend. April 9th, Michael Shaver's Facebook sends Vanessa Townsend, that's when she asked him to contact her at the 0941, the burner phone. And April 11, 2016, Michael Shaver Facebook sends a message informing Vanessa she's about to get a special delivery. And she does. The flowers purchased by Laurie Shaver, as shown in her bank records. She receives the flowers, exposing the affair. But that's not all she ultimately gets from Laurie via the Mike Shaver's Facebook. She gets pictures after picture after picture, text message, screenshot after screenshot after screenshot. I ask you once again to use your common sense. This is Mike Shaver reaching out to inform some other person that their husband was being involved in an affair. Wouldn't this be enough? Wouldn't this picture do it? Why all that? Why? This was Mike. Would all that be necessary? This isn't sent by a husband trying to inform some other person's wife that their partners were having an affair. This is sent by Laurie Shaver because she wanted to drive a wedge because Vanessa would not leave. Well, sorry, Jeremy would not leave Vanessa, and that is what she wanted. September 12th through the 14th of 2016, the cement slab is poured over Michael Shaver's body. That is shown to you by the cement mixer rental being for that period. And then it is also confirmed in Facebook posts a couple days later at Isabel's birthday party on September 19th, 2016. Michael Shaver's body has been in the ground for some time now, but there is no argument that can be made that after that cement slab is put down, that his body was not there. On September 20th, 2016, after we know for a fact Michael Shaver has to be dead, there is a Facebook message to his niece. And this is the one that reached out to him and said, "Hey, Mike, how you doing?" He says, "I don't know you. I don't know who you are." She didn't have the Shaver last name. Laurie didn't recognize her. She's like, "I'm your niece." She talked about how she had discussions with him. Mike knew she was getting married, knew that she was going to be changing her name. And Michael Shaver's Facebook reply is, "I don't have a family anymore. I have no clue who you are. Now stop messaging." September 20th, 2016, after we know Mike has to be underneath that cement slab, he also sends a Facebook message to Vanessa Townsend. "Hi, Vanessa, how are you? Moving good looks good on you. Hope you and your son are doing well." Now, Mr. Wiggs has talked at length with various witnesses about maybe Jeremy Townsend had this phone. Maybe he was just driving up to the house for months and months and months after this relationship was ending to try to get into the router to have the IP address match Laurie Shaver's IP address, and that he was the one that was doing all this. No reason for Jeremy Townsend to send this message to Vanessa, because it's not true. It's just as unreasonable as the idea of some sort of hacker getting into Michael Shaver's Facebook account to post a stupid meme. It makes no sense. because it's not true. Laurie Shaver had access to it. Laurie Shaver had access to the devices. Laurie Shaver had the means and desire to make people not want to come look because she killed them. March 8th, 2017, after we know Michael has been dead for a very long time now, and known that he is underneath that cement slab, the Facebook profile picture has changed to a photo taken by Brendan Burns in 2014 that he says probably texted to him back then. So who would have access to that to put it up on his Facebook profile to try to act like Michael Shaver was still alive? Someone that has his phone. Who had his phone? She did. And those phone records proved it. January 1st, 2018, that is when Michael Shaver's Facebook profile is changed to the random bar picture that Detective Strickland did research into using the reverse Google image to show that had something to do with some sort of Bloody Mary company out in the Midwest, and Michael Shaver's nowhere in that photo. March 14th, 2017 is when the cover photo changed. And that was that odd looking revolver that I think had 700 bullets in it that Detective Strickland made a joke about that's not real gun. Well, it's important to remember that the post of that cover photo and almost the 2-year anniversary of Michael Shaver's death, to put a gun after he was shot in the back of the head, shows that Laurie Shaver's Facebook account and Michael Shaver's Facebook account utilized that same IP address, meaning that they have to be in the same location, the devices that are accessing these accounts. It's the same, whether it's Starbucks, whether it's Laurie Shaver's home, it doesn't matter. It is in the same IP, the same location. Both of those accounts are accessed within 1 minute of each other. Has to be someone that has control of both accounts. There's no other reasonable explanation for that. The Facebook IP limits. We spent a lot of time talking about these. This is the summary that Detective Strickland described. And going through this, you can see how there is activity throughout a 2-year period where both of these Facebook accounts are utilizing the same IP address. Once again, we've been upfront with you since the moment we started talking about this case that we are not going to be able to tell you the physical address of that IP address. But it doesn't matter. Wherever it is, you have to be in the same location to access the IP. And when both accounts are constantly utilizing the same IP address, that shows that that is the same location, the same person accessing that. If you were to go through this and go through all 70 some odd pages, you would see there are 13 separate IP addresses that both accounts utilize over the course of that period. And you heard some testimony about how providers like CenturyLink will sometimes roll that, change your personal IP address to your home every month, maybe every 2 months. What you will see is that both devices utilize a particular IP address for about a month, maybe 45 days. And then it changes to another IP address. And then both of those devices share that IP address for that entire time. There's countless instances in there where you might see the Michael Shaver Facebook address, Facebook account access an IP address, and then the next day, Laurie Shaver's Facebook account accesses that same IP address, and it goes back and forth, back and forth. That is a folder full of those examples. But if you were to go through there, you would not only would you find 13 separate IP addresses that they use, you will see activity on Michael Shaver's Facebook account that continues after the cement slab is laid over his body in September of 2016. You will see there are 31 separate days in that 2-year period where they both access the same IP address on the same day. You will see that there are 12 days in there where there is activity between the Laurie Shaver account and the Michael Shaver account within 2 hours of each other. There is one instance, which we talked about with the gun photo on the almost 2-year anniversary of his murder, that is 1 minute and 7 seconds apart. There's another instance on July 15th, 2016, where the activity is within 6 minutes of each other. This is the same person looking at these, using these. This is one example of the type of thing you'll see in this chart. This is from April 2016 on this side, where you can see there are some days, once again, look through this chart, feel free to do so, where on certain days it's actually going back and forth. Both are being accessed throughout the day. November of 2017, towards the end of that chart, this is where you can see the actual data that I've been talking about, showing the 1 minute. And not only have we given you this summary to try to help you with going through all this information, you have the originals right there, and you can go through it yourself. And you can check it and look at all of that. Justifiable and excusable homicide. Justifiable homicide is going to be the self-defense, defense of others that we will talk about shortly. The excusable homicide instruction is given to you. You heard it, read it. I would submit to you that none of these things apply when the killing is committed by accident and misfortune in doing a lawful act. There's absolutely no evidence of any of that. Accident and misfortune and the heat of passion. Heat of passion is coming in and being so overwhelmed by something that a reasonable person would not act any different. Not to be blunt, but you come in and you see your child being attacked, molested, whatever it may be, and you are overcome with this emotion, and no reasonable person would not. That actually doesn't excuse the killing. It just means that you don't have the necessary intent to commit second-degree murder or first-degree murder. It would be a manslaughter. And when the killing is committed by accident and misfortune resulting from sudden combat, if a dangerous weapon is not used. Well, we know someone was shot in the back of the head. That doesn't apply. Excusable homicide has to be given in every homicide, but none of those apply. Before we talk about the defense of others, I want to go through and talk about the tools the judge has given you to aid in your common sense in weighing the credibility and weighing the evidence in this case. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did they have an accurate memory? Were they straightforward in answering the attorney's questions? I'd submit to you that as you go through this, all of these questions that you ask yourself are pretty common sense, that these are the types of things you should use to try to assess a witness's credibility. Defense of others. The testimony that has been presented to you by the defense is that Isabel shot her dad in the back of the head. And then, just so happened, at that exact same moment, that Jeremy Townsend showed up, grabbed the gun, shot him again, and then threatened to kill Isabel and Aiden if anybody said something. They also say, both Laurie Shaver and Isabel Shaver, that Laurie took her kids to school, that Aiden had no idea anything that had been going on. Gunshot in the back porch, huge fight. Isabel said Jeremy threatened him and threatened to kill him. But Laurie said Aiden had no idea what was going on. I just needed to get them to school. And it was a short trip over to school. All I wanted to do is get them to school and then get back home. That's what she said. And she says when she got back, Laurie said when Jeremy got back, Jeremy was gone and there was no change in the property. She talked about how close this school was to her. All she did was take the kids to school and drive right back. Yet somehow, Jeremy was able to clean up the entire scene, remove the body, and I guess come back some other day undetected and bury it, and no one noticed disturbed ground anywhere. These rules of weighing the evidence and assessing credibility, the judge has told you specifically, since the defendant has testified, you are to use those same questions, those same tools in order to assess her credibility. And when you look at this story, it makes no sense because it's just not true. Now, ultimately, proving this case is the state's burden. We have to prove she was the one that killed him. They don't have to prove to you it was self-defense or defense lawyers. We have to prove to you it wasn't. And we have, because all of the evidence shows that Michael Shaver was not alive in November, was not alive when this happened, because he's been dead since November of 2015. Somehow, Isabel, who shot her dad in the back of the head and went to school when she was 7 years old, has absolutely no memory of what year or what month this happened in. What grade were you in? I don't remember. I don't know. What month was it? I don't know. I think spring or summer. What year? No clue. And she said she went to school that day and carried on like nothing happened. It's the state's burden to prove this case. But if you are fed a story that is just patently false and fails all common sense scrutiny, ask yourself, why? Why did they come up here and try to feed that to you? Because to cover up the reality that Laurie Shaver killed her husband back in November. And they're trying to give you a story, and they're trying to fit it in to the timeline that has been established over the course of this case. Because also remember, in the very beginning, when Laurie Shaver was arrested, you heard testimony that her attorney said, you need to look into two people. You really need to look at these people, Jeremy Townsend and James Ballou. Okay? Well, if this is the story back when Laurie was arrested in 2020, why bring James Ballou into this? That's not part of their tale. That has nothing to do with it. But that's how the story started. And then as the evidence progressed, then in 2022, Isabel shows up as this potential witness. And despite what Mr. Wiggs told you in the very beginning, that we were offering the truth to the state, and they shut the door on us. They said, we don't want to hear it. They want to talk to her. But you heard from her attorney. What does she tell you? Every time after she became the attorney of this witness, I would see her and say, hey, anytime your client wants to come and talk, I'm here. Does that sound like the state shutting the door on his theory? Or is that just the convenient tale they want to tell? And we went through Laurie's Facebook because it has been 9 years since this happened. The person, Isabel, that you saw testify is a much different person than the little girl she was when she says she shot her dad. These are the pictures of Isabel from back when she says she shot her dad in the back of the head. Went to school, carried on like nothing happened. And then this great, wonderful mother that Isabel described, who is saying that these two were involved in this horribly traumatic incident in 2016. She go get her therapy, counseling. Maybe she needs to talk to somebody about the fact she shot her dad in the back of her head and was threatened by her mom's boyfriend. No, one time this year, I saw a counselor and talked to somebody. We're fine. No.
Only guilty man in Shawshank.
The story makes no sense because it isn't true. But the evidence completely disputes their tale. Dr. Coberly told you that this is a single gunshot to the back of the head. Isabel told you, I shot my dad in the back of the head. He sat there, he started shaking, he started seizing. And then they said Jeremy came up and shot again. There's no damage other than post-mortem rib breakings from after the body was buried in the backyard for years. Also makes absolutely no sense that if someone was coming in to finish someone off, give them a coup de grace shot with a gun, if they want to put another shot in the head, that they would shoot him in some soft, fleshy area so as to not hit any bones. But this injury, Dr. Coberly looked at underneath a microscope, and she says there is no doubt that is one gunshot. She says even when you have a scenario where somebody takes the gun, pulls the trigger, and immediately pulls the trigger again in that exact same spot, there's going to be derivations, there's going to be enough movement that they can see kind of a figure eight type of movement, figure eight type of configuration, to show that there was more than one shot. There's also only one projectile in the skull. Probably didn't even need that explanation of the microscopic examination because there's only one bullet there. But scientifically, we know Michael was shot one time. Going back into those tests, going those questions. Does the witness have some interest in how this case should be decided? Laurie Shaver, Travis Miller, and Isabel Shaver are the only witnesses in this case that had an interest in how this case should be decided. Isabel Shaver said, I love my mom. I don't want to see anything bad happen to her. I want to keep my family together. And I understand that. But that doesn't mean what she told you is true. Was the witness honest and straightforward in answering the attorney's questions? I want you to think about Travis Miller and target his discussion of this commitment ceremony on December 31st, 2016. No, nobody thought this was a wedding. We didn't represent this as a wedding. Was she wearing a wedding dress? Yeah. Was she walked down the aisle by your grandfather? Yes. Was there someone there conducting the entire ceremony? Yes. Her testimony from other people, well, they absolutely told us it was a wedding. You also saw the Facebook post that Laurie put up announcing their engagement, saying that I'm going to be a filmer. Now, is that in and of itself the big earth-shattering aha moment? No. But if you can't trust them on the little things, how on earth are you going to trust them on the big things? Laurie Shaver, as far as honest and straightforward answering the attorney's questions, you got to see the way she testified. You got to see her temperament. You got to see all of that. But also, once again, the little things. Was this your phone number? I don't know. That's the types of tools you can use in assessing their credibility. Does the witness testimony agree with other testimony and other evidence in this case? Everything except for Laurie Shaver and Isabel Shaver show you and tell you Michael Shaver has been dead since November of 2015. And if he's dead in November of 2015, he definitely isn't showing up unannounced 6 months later for the first time on their porch. I guess wearing his nothing but his shorts, socks, and underwear, because that's how the body was found in the ground. Is that somebody that just shows up unannounced and starts a fight? Or is that somebody that was at home, sleeping in that bed when he was shot in the back of the head? Even Laurie Shaver and Isabel Shaver's testimony conflicts with each other. Isabel Shaver said her father had not been living at home since 2014, since that DV arrest in 2014. Laurie testified actually consistent as far as that living arrangement as other witnesses that you've heard from, where she says, no, he was living there. But Isabel, now Dad hadn't been there since September of 2014. Also, Isabel says, Jeremy said he was going to kill me and my brother. Laurie says, Jeremy said, if you tell anyone, DCF will come and take you away from the family. Their stories don't even match. Because it's fabricated. It's made up. It's flat out not true. And it's inconsistent with everything else that you have heard. The only witness that Laurie got up there and say wasn't fabricating something was her daughter. Scott Amatuccio. He's lying that he's actually friends with Mike. They weren't really friends. Heard from Katina, like, oh no, they were great friends. Frank Barrett. He's lying. I never told him Mike went to Georgia. Jeremy Townsend. All sorts of lies. He would spend the night. He would be it. That right there is should be a huge red flag to you. If Jeremy Townsend was out spending the night at someone else's home 3-4 times a week, the way Laurie and Isabel tried to tell you, Vanessa would know. She wouldn't need someone to send her flowers with a card to expose an affair. Vanessa had no clue that anything was going on because Jeremy would go over in the middle of the day the way he told you. Robert Mercado is not being truthful when he said that Laurie got upset one day and was threatening people with a gun. Austin Filmer is not telling the truth when he said that he went over there and helped Travis lay down this concrete slab. Vanessa Townsend obviously is lying because she said there was never any time that Jeremy was missing at night. He always came home. He was always living at home. John Borglum apparently is lying about the reason why he terminated Mike Shaver, because Laurie got up there and said, no, he was fired because of a sexual harassment claim. So also, I guess Disney's lying when they sent over all of Mike Shaver's work records and just hid any sort of sexual harassment claim against him. But today you actually heard the truth about that sexual harassment claim, and nothing to do with Michael. She called it in against Kendall Davidowski, the woman that Mike Shaver was dating when they were separate. Kendall got up there and said, yeah, I worked at Disney. Laurie Shaver called in and made a complaint about the relationship I had with my chief. So everyone is lying about Laurie, but Laurie is the only witness that you heard from that actually admits lying to other people. She admits lying to law enforcement. She admits that when they came and said, "You know what happened to your husband?" She said, "I don't know." That was a lie. She knows he was dead. She tries to say, "I had no idea he was buried in the property. No idea that he was under this cement slab she poured." But as far as anything that happened to him, no clue. She admits lying to Rebutting, her former boss, about the fact that after Michael Shaver was dead in November, she told her former boss, "Oh, he's in jail somewhere for failing to pay child support and his driver's license suspended." She admits that was a lie. She lies to her son, Aiden, because she says, after I saw Mike killed in the fashion they try to say it happened, she told her son that her dad went away and went to jail. Even if you're trying to cover this up and trying to tell something to the son, why say your father went to jail? That's spite. That's absolute spite on this man that she killed. And then Katina Vasquez, who testified here today, that this whole thing you heard about in 2014, how this is just so indicative of what happens in the household and how she was abused by Michael and all of these things. What did Katina tell you? Laurie told me that was a lie. Mike should have never been arrested for that. I was the aggressor. I threw the mace. I broke the slide glass doors. I hit him with the gun. Mike can't get up here and speak for himself and defend himself, but he doesn't have to. Because people like Katina come up and tell you the truth about Laurie's lies. Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Tammy Dale talking to Isabel. Do you know what happened to him, your dad? Isabel, I have no clue. I don't know. He just left. At the CAC. So you did not see anything that happened that would have made you have an idea of what happened to him? Isabel, no. The last time she remembered seeing him.
Is there an objection, sir? Yeah. Sidebar, please.
Sidebar. Everybody loves a sidebar. All right, should we do some shots? I think we should. I really think we should. Wow. What a party that is. That soundbite is the biggest party. It's like a 2-second party. I'm all here for 2-second parties. Because I'm old. I'm already tired. 2-second parties about all I can handle these days. Yeah. He's got to be close to wrapping. How long has he been going? See, we started. I don't know how long I yapped before he got going. Probably about 20 minutes. It's got to be close. It's got to be close. Yeah, I mean, he's telling the story effectively. You know, and it's important because circumstantial evidence requires the story, the theory. Got to lay the theory out. And yeah, I think he's doing a pretty good job. Very matter of factly, you know. And then other dude will land the plane in the rebuttal closing. But prepare yourselves. I want you guys to all strap your seatbelts in. take your anti-nausea medicine because Hank Hill, he coming for you.
May it please the court, Your Honor, esteemed jurors, I just want to tell you, my client, she didn't do it. Let's go.
Yeah, it should be good times. Good times. Look at Brooklyn with the salient. What a great word. What a great word. Yeah, hour 10.
Judge, he's making my client sound guilty. I don't appreciate it, Your Honor. He's stacking all the facts, Judge.
Statements. Just remember what Isabel was testifying about. I asked her, did you tell this to Sandy Dale? Did you tell this to CC? She admitted, I told these inconsistencies that are completely different from what she testified. Now, I will also submit to you that back when Laurie Shaver was first arrested is when these statements were made. And this, I don't know, he just left, is consistent with what Laurie Shaver told every other person that came with. In 2020, I believe that the evidence is completely clear that Isabel had no idea what happened. The only thing she knew is what her mom told her, and that's that he just left. And that this story was fabricated. Travis Filmer states in depo that the reason Laurie did not want a legal wedding was due to financial issues. Yet at trial, he said she didn't want a legal wedding because, quote, she did not want to sign a contract with another man. And he started talking about, oh, poor Laurie and the things that had happened to her. But when he was actually presented with that depo transcript and given an opportunity to show me where he had said any of that before, he couldn't, because he didn't say it because it wasn't true. And also, this whole thing about not wanting to sign a contract with another man, we know that's not true because they ultimately got married once they legally could. Once it was discovered that her ex-husband was in fact dead, they got married, and you heard testimony about that. So all of that, not true, completely inconsistent. Travis Filmer states to Robert Kroger and law enforcement, but Laurie said it's not that the victim is missing, it's that he is no longer walking this earth. And he just flat out denied it. But his friend, mentor, Robert Kroger, and his twin brother, who said he overheard that comment to law enforcement, came in to verify it. Then Travis Filmer had told his brother, Austin, that there were times that Laurie would get his phone, send texts to Austin, basically posing as Travis. I asked him, have you ever said that before? He said, no, that's never happened, no. Austin, his twin brother, came in and said, that absolutely has happened. He's absolutely talking to me. And I could tell because we're twins. The way we communicate was completely different from the way she was communicating with me. Which is the same thing you've heard from every friend and family member that received texts and Facebook messages from Laurie Shaver, posing as Michael Shaver, since his death in November. Brings us to count 2, the accessory after the fact. The judge has read you the law on this. I'm actually going to hold off in talking about this charge a little bit until after Mr. Wiggs has talked to you. I will tell you that
He's doing both?
not be guilty of the murder and as an accessory after the fact to that murder. Accessory means they were helping another person. The evidence we have presented to you proves beyond a reasonable doubt that Laurie Shaver committed second-degree murder. And because of that, the verdict should be guilty of murder in the second degree using a firearm and not guilty of
Right.
accessory after
Exactly.
because you can't be guilty of both.
Correct.
But the law does allow the state to present these alternate theories depending on how the jury perceives the evidence to make that final conclusion. But I will tell you that the evidence that has been presented is not that in May of 2016, Jeremy Townsend shot this man in the back of the head and Laurie.
I'm very, very happy that he brought that up because obviously you can't have both things, you know. That's why when I was reading that that instruction, you know, like the concept of being an accomplice to yourself is just something that you cannot do. Well, basically, Chavo, what he's saying is can't do both. It's either you're the murderer or you're the accomplice, not both. So, say for instance, had they charged Isabel and she was on trial, they could obviously bring, and they believe that Laurie was the one doing all the texting as opposed to Michael buried 3 feet under the ground through GhostNet, with his Beyond the Veil plan. Brooklyn just on fire today. Brooklyn's always on fire. It's a good thing that we have Brooklyn because when Mandy's not here, we need that. We need that happening for us. So yeah, we need that snark in here. Did I do something crazy? What did I just do? What happened? Is that me?
Presented is not as simple as just guilty or not guilty.
Shoo.
We talked
But bottom line, it's one or the other. Can't be convicted of both.
about manslaughter being a lesser included, so that is on here as well. The judge will instruct you that you are to find the defendant guilty of the highest level offense that has been proven beyond a reasonable doubt. So I would submit to you as you start your deliberations, to start with the murder and go through those elements. Because if the murder is proven, manslaughter is obviously included, so that's proven as well. And you don't have to go to manslaughter if you all agree that the murder has been proven beyond a reasonable doubt. But there's also a couple questions here for you that you will also have to decide that deal with the use of a firearm. And that is crystal clear. There's a bullet in his head, a bullet hole in the back of his skull, but the law requires that you actually designate, yes, she was in actual possession, meaning that she had it in her hand when she shot Michael Shaver in the back of the head. She discharged the firearm and it caused great bodily harm or death. The state has presented to you evidence beyond a reasonable doubt that this was not self-defense. It was not defense of others, but it was murder in the second degree. And therefore, the verdict consistent with the law and the evidence is that she's guilty of second degree murder, and that all three of those questions should be answered yes. Mr. Wiggs will be up here and talk about what he believes the evidence is shown to you, and I'll just remind you what the judge said, what the lawyers say is not evidence. You're to rely on your own memory of that evidence and what things were presented. So if either myself or Mr. Wiggs are saying something and you're like, that's not what I remember, you go back to your notes and you look and you make sure what you're being told is valid. And it's actually what was presented to you today, this week. Thank you.
All right.
All right.
Thank you, Mr. Comicchio.
Effective.
Mr. Wiggs?
Yes, sir.
Can I ask you one more question? What and what accessories do I sell
It's been a
for a
long
living?
week, hasn't it, everybody? And I appreciate y'all being here. I appreciate your attention. I know it was an arduous event. All of us sitting here listening through that, all of the breaks at the bench, all those interruptions, it can be very annoying. It can take a lot of time. It's very distracting, but those things have to happen. In the voir dire, you'll remember, I stressed to y'all extensively about the Constitution. This is something we don't take for granted in a criminal case. Some people may want to downplay it. Some people may want to compromise our rights, the responsibilities, and the privileges that we have. They can't be. They cannot be compromised in the slightest event. This is a privilege we have. It's a constitution that is endured. It was created by hardship. for men and women like us to live under the system we have. This system goes, we'll never have it back. We will never get it back. And it is at jeopardy at this stage. I told you that the founding fathers in this Constitution, they recognized that liberty comes with an extreme price. To deprive somebody of liberty comes with a lot of responsibility. Not coming in here, throwing a bunch of mud on the wall and saying, yeah, there you go. There you go. Oh, she lied about this, or here's another misstatement, or here's another misstatement. Laurie Shaver is not on trial for lying. Laurie Shaver is not on trial for bank fraud. Think about that. That the state has the audacity to come in here and state money's moved, thus she committed a murder. Guns were sold, thus she committed a murder. There's a car in the yard and a misrepresentation, somebody went somewhere, thus causation. That's a huge leap, an extreme leap. Remember we spoke about in Vordaer, and I kind of used an example, and I said, I had seen on TV about, and I believe it was Joe Rogan and Jordan Peterson talking about, I think it was Rogan talking about, and he said, I see photos and stuff and talk about UFOs. And he said, and I hear this, and I hear this, and I hear this. He goes, I really would like to believe in UFOs. And he says, but, there's just not enough to put it all together for me. And Jordan Peterson said, yeah, that's a conspiracy theory. What does the state put together here this week? A conspiracy theory. She lied about this. Here's a misstatement. Here's a misstatement here. Here's a misstatement there. She must have murdered the guy. Think about that. Think about the draw and the stretch that the state has put out.
How dare this man compare this murdering psychopath to the existence of alien life? How dare him? How dare him?
She had a motive. All right. That's a big stretch. Okay. I want to talk about the law foremost, and then we'll go over to some facts. And I'm going to show you.
This is what he gets for that.
Can I ask you one more question? What and what accessories do I sell for a living?
So good.
Indisputably, irrefutably, how more than one reasonable doubt exists in this case. And we know what your responsibility is. And I just ask that everybody abide by it. In the instructions, it talks about, yes, what are the elements of a homicide? When the killing, okay, excusable homicide, now we're talking about. When the killing's committed by accident or misfortune, okay, was Michael part of his own misfortune? Obviously. 2, when the killing occurs by accident, misfortune, or in the heat of passion, okay, Michael brings on his own death. Michael comes to the house when the state never established his right to be there. We know there were injunctions in place periodically. 3, when the killing is committed by accident or misfortune resulting from a sudden combat. All right. The state wants you to believe Laurie lied about this, or there's a misstatement here, or she's sleeping around. Why did we have to hear that testimony to disparage my client? To think they're going to get emotional impact out of you? Is that relevant to this cause? Is it probative to a material fact that you have to decide? No. It's disparagement for the attempt to pull an emotional result out of you to fill in a verdict form. I told y'all at the beginning in my Vordaer, the state has a responsibility to seek justice. And I said, what is the state seeking here? They're seeking a verdict. That's what it is. So most of what you heard, if not all of what you heard, is an emotional ploy for you to go back there and out of anger for Laurie Shaver, fill in a verdict form for the state. That's what's going on. That's what you've heard this week. Second-degree murder. Mr. Camuccio went over the elements, so I'll briefly touch on it again. The defendant's dead. Yeah, we know he's dead. Okay. The death was caused by the criminal act of Laurie Lee Shaver. Okay. Has any single witness taken the stand and shown you one piece of evidence that established Laurie Lee Shaver killed Michael Shaver? Zero. Zero. Case over. Period. What they've done is brought in a bunch of digital data after the fact, after the event, and said, well, she tried to cover it up, or she didn't want to talk to this person, or she didn't want to talk to that person. Well, there's a good reason she probably didn't want to talk to numerous of these people, but a lot of it probably didn't have a darn thing to deal with the death of Michael Shaver. 3, there was an unlawful killing, an act eminently dangerous to another, demonstrating a depraved mind, without regard for human life. Okay. Has anybody established a depraved mind? No. Without regard for human life? No. Laurie Shaver was in her house when she was attacked. That's what happened. Did the state offer any evidence on causation, where this event occurred, how it occurred, any different than what the defendant and her daughter testified to? No. No. In fact, you may remember Tamara Dale. She gets up there, and I talked to her about it. And I said, you don't have any DNA, do you? No. You don't have any prints, do you? No. You have nothing in the scene in the house to suggest any activity, do you? No. You don't have anything in a gravesite, do you? No. You don't have any prints in there? No. You don't have any DNA in there, do you? No. You don't have any gun that links Laurie Shaver to the crime, do you? No. You don't have any confession, do you? No. You don't have any witness, do you? No. She admitted all that. And then her response was, well, how could we solve a murder any other way if we had to have all that stuff? Because you normally have that stuff if a murder has occurred and it's attributable to one person. The state tried to compromise that obligation. Do you remember? Do you remember how? They said, hey, Mr. Camuccio said, you're not going to hold us to that standard like CIS that you see on TV, right? Trying to lower what you could expect to see in this case. You're right, he said that, because he knew he didn't have any evidence. So we wanted to mentally prepare you to get you ready to not see evidence. That's what that was all about. You remember his statement earlier as well? We talked about the burden of proof. You'll remember that. And I talked about it in voir dire, and I talked about it, and I said, it's kind of like a football field. I said, in a criminal case,
I'm going to object.
this is an analogy for closing.
Let's have a sidebar, please. Thank you.
Sidebar, sidebar. Everybody loves a closing sidebar. Yeah. Yeah. All right, let's have a party. Let's have a 2-second party. Like right now. Let's do it. 2-second party. 2-second party. There we go. Nice and easy, quick. In and out. In and out burger. All right. I'm out of free gifted memberships until October. In October, then they're back. Another 10 glorious, glorious free memberships. Oh, yeah. Oh, boy.
But Judge, I didn't object when he was making words. Oh, Bobby, look, Judge, this is a tough case. I'm having to try to sell this to this jury here, and this man is interrupting me. I don't know. Okay.
He did object one time. We did. We had a try. Didn't we have a sidebar? State sidebar when the state's closing.
Football field. And I said, look, if it was a civil case, then the standard is beyond reason, is by a preponderance of the evidence in a civil case. That's just tilting the scale, getting past kind of the center of the field. But in a criminal case, where our founding fathers put the premium on liberty and the obligation on the state, I said it's the highest standard required under the law. You got to be on the end of the field down here. There's a high difference between this, which can't be downplayed in this case by the state throwing some mud on the wall and saying, oh, there was a lie here or there was a lie there. You see, the state can't compromise that. Let's go on a little bit. When we talk about depraved mind, and you hear that word, and you'll have a complete set of these instructions. You go through them at your leisure, need be. Okay, it says, an issue in the case is whether Laurie Lee Shaver did not have a depraved mind, with that mind without regard for human life, because she acted in the heat of passion. Okay, unadequate provocation. In order to find that the defendant did not have a depraved mind, then it gives you some factors to consider. There must have been a sudden event that would suspend the judgment. B, a reasonable person would have lost normal control. Driven by blind or unreasonable fury, there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act. Y'all saw these photos. Y'all know there were repeated acts of violence in that house. This was not a blind event that Laurie Shaver just stepped up.
Oh, we finally got to see a picture.
Said,
Kind of.
I'm not going to act. They knew what was coming. And this is evidence that they knew what was coming. We had multiple injunctions that were filed with the court. Michael Shaver had been prosecuted in the past, and the state wants to sit here and say, hey, this was some blind event and she just murdered her husband.
What is he doing?
I'd like to hear an explanation for that.
I'd like to hear an explanation about what the fuck you're talking about. Like, wait, did she shoot him or didn't she? Pick a lane, dude. Like, this whole concept is insane. The reason why they didn't come forth with a self-defense defense is because he was shot in the back of the head. That don't work. That don't work. Can't shoot somebody in the back of the head and say it was self-defense. I don't understand. I still do not understand it. Like, been practicing law a long time. I do not understand how he was able to convince the judge to put that self-defense instruction into play. It makes no sense to me. Is he now saying, it sounds to me like he's saying, oh, well, they can't sit here and say that nobody saw this coming. This was just like, she was beaten for years. So he got what he deserved. Is that what he's arguing right now? Because it's what it seems like what he's arguing to me right now. I'm so confused. I'm so very confused. Talking about, yeah, throwing like every piece of shit against the wall to see what sticks. This is it right here.
Move on, son.
Yeah, let's move on a little. That shit don't make any sense, bro.
Let's talk, because the state's going to have the last word in this case. They always do. We don't have the privilege to respond to their last word. Okay? Let's think about this. She's charged with accessory after the fact as well as a crime. What are the elements of this offense? And let's think about it. They state that a murder in the second degree was committed by another. State has a real courage to announce who that another person is in the elements or in the information. They don't have the backbone to tell you here who the actor is, who the principal is. And yet they'll come into court and say Laurie did it.
Oh, this one?
Then it says after the murder, Laurie
should.
Lee Shaver
I'll talk to Bill
maintained,
about that. He's going to be in London.
assisted, aided, or attempted to aid
That's a
another
great
person.
idea.
Stop right there. We see and hear talk about money going into the bank or going there. Okay? Is there been any showing in this trial how any money was moved to assist, aid, or attempt to aid somebody in escaping detection of a crime? No. Laurie's using money to live a life, feed her kids, that the state can't not deny is marital money, equitable money, that she didn't have a right to touch it, anything like that. But it's all a pull for you. And then it says, and at that time, Laurie Lee Shaver knew that the other person had committed murder. Okay, let's think about that. That's an important element as well. And I'll tell you why. If you have a right to self-defense, no crime has been committed if somebody dies. No crime occurred. So you'll have to assess, was there a right of self-defense? If so, no crime has occurred. 2, where was money being spent to aid detection for somebody who had not committed a crime? You see? Does that make sense to you? Under the justifiable use of self-defense, it represents, and I'll just highlight some of this for you because I want to talk about facts. It says Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel was justified in using or threatening to use it if she reasonably believed. Now we know the history in this family. That's undisputable. That's physical. That's not to be questioned. Was necessary to prevent imminent death or great bodily harm to herself. Okay? And then it goes on and tells you, well, what's the type of harm that they suspected would happen? Michael's trying to kill her, or he's trying to commit an aggravated battery. And then the instructions tell you what that is, what the elements of first degree murder are that Michael's trying to do, or how he's trying to create another hard battery on her. Okay.
I don't care that he's all over the place. What I'm confused about is he is adamantly denying that his client shot Michael Shaver in the back of the head. Yet he's sitting here out of the other side of his mouth talking about how it was in self-defense. Maybe. It's just it's a strange, because self-defense is what they call an affirmative defense. Like, I have to give notice if we're going to be presenting self-defense. I have to file notice with the court. I have to give notice to the state. And it's like, when you're going with self-defense, you're making an admission that either, yes, I struck somebody, or yes, I shot somebody, or yes, I stabbed them, but it's okay. It's justifiable because I was defending myself. Like, that is not what they're saying. That is, like, that's not what I'm so confused by what is going on here. Like, I don't know. Like, I'm gonna have to research and see if they have some crazy ass law in Florida where you can say that your client didn't do it, but yet claimed self-defense. It's like weird.
Okay? And that's spelled out in these instructions. Then the instruction will tell.
Yeah, but Isabel's not on trial. Isabel could certainly come in with defense of others. If they had tried her, Isabel's not on trial. So, but in defense of others is not. Remember, it's exactly what I just said. For self-defense, it's essentially an admission that, yes, I made physical contact in the case of a battery, or yes, I shot or stabbed somebody in the case of a murder or a aggravated battery. But you're making the admission that you did it. Like, I've never heard at any point during this trial them saying that Laurie shot him. It's been denial the whole way through. It's a whole different thing if Isabel's been charged, because Isabel would have been defense of others. He was beating my mom to death. I got the gun. I shot, but she hasn't been charged. Can only the defenses only relate to the defendant, not everyone else.
Tell you as well that justifiable use of force is justifiable if Laurie or Isabel reasonably believe that the force was necessary to prevent imminent death, meaning that a murder, attempted murder on her, or great bodily harm. Has the state eliminated this defense? No, not at all. They want.
If all what was true, if, like, which side, their story or the state's story? In the defense's story, she doesn't shoot anyone. Isabel does. Isabel is not on trial. Isabel was a witness. She's not been charged with anything. She can't walk out of here. No, the jury can never say that Isabel is guilty or innocent of anything because she's not the defendant. You guys get that, right? So the story, as we've heard in the last 5 days, is that Laurie didn't shoot anybody. Ever. Now she's trying to say that her daughter did it, but her daughter's not on trial. The state didn't charge her because they think that story is a big stinking load of shit. So, it's like, I'm just telling you, talk about cognitive dissonance. This is it. This is it defined. It's self-defense, but she didn't shoot him. Yeah.
Want to throw mud on the wall and say, well, she lied here. She spent some money here. But they can't say first and foremost, she didn't have a right to defend herself, to establish that a crime even occurred.
I know but that's the very instruction that I'm talking about, that I'm so confused how it's in here. Dizzy, you got to go see and see if they filed a notice, Diz, for an affirmative defense of self-defense. See if that's in there.
It's actually, listening to this case, I got to tell you, I'm spun around listening to it. The judge is going to give you.
Yeah, but this, I hear what you're saying, Freedom, but for the accessory after the fact, that means that they're finding her not guilty of the second degree murder. And you don't need a self-defense. Like the affirmative defense of self-defense is not a defense to accessory after the fact. So that doesn't make sense. Like it doesn't make any sense either. Yeah, because like that's when I first heard it. When they had Isabel's name in the self-defense instruction, it confused the hell out of me. Really did.
You an instruction because they've made an issue in this case out of this. And it's an important instruction because it kind of strikes a nerve in all of us. And it says this: you must understand no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. Laurie Shaver could watch Jay Townsend shoot somebody and had no duty to call the police. Isabel would have no duty to call the police if she hadn't shot him or done anything. Okay? That's a fact. That's a law. The state will act otherwise. Like, no, they could have called 911. Why didn't you call 911? Again, we spoke about this in board. Let me grab it.
Thank you both, Freedom, the $5 heart, and also for Michelle, the $10 heart. Appreciate you both. Thank you. Which part is which part?
Say, excuse
True.
my handwriting. Okay? Probably the worst penmanship in the state of Florida. Anybody. But anyway, the judge will tell you that a reasonable doubt, they're in your instructions. I briefly spoke about it because this is very important. If there's one reasonable doubt, it is the requirement, the responsibility, the necessity of any and every jury to return a verdict of not guilty. Not guilty.
Yeah, that makes sense,
How
Freedom.
does it arise? From the evidence. It can arise from the evidence itself. It can arise because of the lack thereof in the evidence. It can arise by a conflict in the evidence. Those instructions tell you. And they further say that if your feeling is not stable, but one that wavers and vacillates, you got a reasonable doubt. You see? Now let's shift over to the facts and talk about some of those facts. One we spoke about, and I want to remind.
Well, Freedom has a reasonable explanation. So what Freedom is saying is that in order to get a conviction on accessory after the fact, there has to have been a crime committed, right? So what Freedom is saying is that by way of defending against that lesser included crime of accessory after the fact, that he somewhat has to defend that Isabel's actions were in self-defense of her mother or in defense of her mother. So, I mean, maybe, I mean, that's got to be the way. No, I get you, Freedom. I mean, that's a plausible explanation. I mean, the way that the state's setting it up is going to be very confusing to the jury because no one's articulating that. You know, I mean, the only explanation they got, I was grateful that the state gave an explanation that they can't find her guilty, Laurie, of both of those. It's one or the other, or neither. But they can't find her guilty of both accessory after the fact and the second degree murder because you can't be an accessory to yourself. So yeah, it's a weird thing. I wonder if they'll clarify that during the state's rebuttal closing. But you know, that's a tricky gambit for the state because they obviously, I mean, if they had to take it in terms of a conviction in this case, they'd take it. But obviously, their druthers are to get her on the second degree murder. So you know, the state's not spending very much time trying to argue the accessory after the fact, that would essentially be like an acknowledgement, because that's you see why that's a very slippery slope for the state. Like the state, like I'm surprised they included that, because in order for the state to argue that they could convict her and they proved it beyond a reasonable doubt, they have to acknowledge that it's a possibility that Isabel actually did shoot her father, or Jeremy Townsend actually did shoot Michael Shaver. And that's a problem. That's a problem for the state, you know? So it's like, like, frankly, I'm a little surprised they included that charge. But Freedom, I agree that's the only way that makes sense. But the state is basically refusing to argue it.
The burden of proof is entirely on the state. Ms. Shaver was not required to take the stand, expose herself to criticism, ridicule, or a misstatement here or there. That burden stays on the state. We know in this case, it became evidently clear, and should be to everybody here, that Ms. Shaver was in a marriage that had gone bad. It was a case of where children lived in an environment that, as Isabel said, it just became commonplace to see these things happening. My dad striking, forcefully, acting out on my mom. And she said, I soon developed an attitude of feeling a need to protect my mom. I soon just responded with a attitude of response trying to protect my mom. That's how bad it got. So she said on the day that this happened, she goes, she was kind of in shock, went to school and just kind of tried to put it out of her mind. And that's what happened. And yet the state, despite all this, wants to criticize that girl who's a victim in this case. Shame on them. This little girl is a victim of a house with continual domestic violence, and the state says, well, why didn't she get counseling? Why didn't she get counseling more? The state chose to ignore this girl. She was brought to their attention, as well as Mr. Ballou. Mr. Ballou had prior tensions with Mr. Shaver. That's why his name was mentioned. Mr. Townsend's name was given to the state. The state took no aggressive action to look into this case. I asked Tamara Dale, state talk to you about this? Did you make any efforts to go see her? Not ask Kelly Johnson, hey, you know, if she wants to come by, why don't you just bring her over? I mean, is that investigation? That's not investigation. That's just saying, bring us some evidence. You know, we'll maybe look at it. State was aware of the domestic violence in the house. They had evidence. They had prosecuted Mr. Shaver for a battery. They knew about it. Wilma Nichols gets up there on the stand and says, yeah, well, Michael's story at an earlier date and time was that his wife attacked him. I said, are you talking about the same incident where he was prosecuted and the state went after him? Well, yeah. Yeah, that had a lot of merit, didn't it? There was nothing contrived by Laurie Shaver and this minor child. Now listen to me. The judge is going to tell you, you had the privilege of believing all, some, or none of the witnesses' testimony. So if you find that there was misrepresentations by Laurie Shaver here or there or one way or another, okay, you can disregard those. You can say, I don't believe that truth. But again, whereas the state led you to believe that Laurie Shaver killed Michael Shaver, they haven't. There's no evidence in that regard. We know there was times when Michael was not residing at the residence. That wasn't contradicted. His former girlfriend gets on the stand and says, yeah, he was living at the hangar here and there. Laurie said, I let him in the house. There were injunctions. He was coming and going. Did the state offer evidence that there was not an injunction or he was not restrained from the house, not permitted into the house on a date specific when any homicide occurred? No. No. Now, let's shift over to, for a moment, to the digital data. That was interesting to me. Kind of interesting. Okay. You got some guy at the sheriff's office, corporal, he had to advise me, that does some tech work out of there. We never heard his qualifications, any experience really he had. Okay, I heard a lot of arguments from him, but we heard Connor take the bench, a man that had been involved in, I don't know how many trials, federal trials everywhere. And he had testified in court with his special skills. And he spoke to us real clear and simple.
Skills.
And he said,
his special purpose, even. We all found out what his special purpose was when he got on the stand. It was IT. He had learned all he needs to know about IT from the man with the special purpose.
now think about, he said this, the IP records from Facebook, CenturyLink, etc. At a point in time, they expire and don't tell you the physical address it's coming from. They may have IP logs.
I mean, nobody on YouTube talks more while they're muted than me. I'm the king. Undisputed heavyweight champion of talking into the mic while I'm muted. It's undisputed.
Records, you see, but you don't know where it's coming from. It could be Starbucks, it could be overseas, it could be here or there. So the state, trying to throw some mud on the wall, says, look at these IP logs, look at this, look at this. But you know what? It doesn't tell you where it's coming from, any device, or any user. You see? That's a significant fact. So the state says, well, somebody sent this and somebody sent this and this went here and that went there. That would create a lack of evidence, a conflict in the evidence as well. And it certainly would not create stability in the way in which you think about it. If Jeremy Townsend is sending some of these, he could be at Starbucks, he could be at his house, he could be anywhere. He could be in a driveway, and he certainly had a motive that can't be excluded.
Wow. Wow. That's all I have to say.
Can I ask you one more question? What and what accessories do I sell for a living? Can I ask you one more question? What and what accessories do I sell for a living?
Oh, yeah. Hank knows. Hank knows.
Now, this child wants to be the state disparages this child because she doesn't know it's state specific. She said sometime in the spring. She didn't say summertime. Mr. Camuccio went on and he said, now today, well, she said the spring and the summer. And that's not true. Mr. Camuccio's not presenting evidence here today, but some of his statements were not accurate as to the content of the witnesses themselves. You'll have to rely on your memory, the notes you've taken here. Now, there's a discrepancy, exactly, precise.
I think it's safe to say that all great hackers are always staged at Starbucks, right? I mean, that's facts. All great hackers are always set up at their Starbucks.
nicely, and what Laurie said and what Isabel said. Isabel, I believe, says, and you have to rely on your memory, she made some statement to the extent Jay threatened to kill us or something of that nature. Laurie said he implied it or something to the children. There was a little discrepancy, but they got the message loud and clear. Okay, don't tell anybody or you guys are going to get in trouble and you're going to be harmed. So one, she doesn't have a duty to report anything, and somebody's threatened her. She's been the victim, we know, of repeated violence. It kind of makes sense this woman doesn't want to come forward with that kind of threat against her. It kind of makes sense that Isabel is not going to school and wanting to tell everybody all about it as well. Now, let's talk about a little bit about this shooting. The state's made issue of this, and I want to bring something to your attention, and I hope you picked up on it in trial. We heard from Dr. Shaw, the medical examiner, and we heard several things I did, and it was brought out through his testimony. One, he said there was a gunshot here to the rear of his skull, and we know that, okay? And I elicited testimony from him when I said there was no soft tissue on this body, correct? Yes. And I said, could it be that somebody shot through some soft tissue and that may account for the presence of the shrapnel? He says, yeah. And so you may have a bullet that goes in, exits an eye, and there's some shrapnel in that skull. I asked him, did anybody do any meteorological testing on the fragment together with the shell to see if they were linked together? No? Now, who's in charge in directing them to do these things? The state. Does that create a lack of evidence? Correct. Does it create a conflict in the evidence? Yes. Does it create stability in your mind? It shouldn't. Okay. Whose obligation is that? And the burden rests with to come in here and prove these facts? The state and only the state. Now, one thing further I brought out through Dr. Shaw, and I know you all probably heard it. I don't know if you picked up on the significance of it at that time, but I asked him about injuries and the nature of the injuries that existed on this body. And I said, were there post-mortem injuries to the body? And he said, yes, there were. And he noted several ribs. And he said those were post-mortem injuries. And I said, when we talk about post-mortem injuries, how do you identify them? And he described about buccal fractures in the ribs and the way to identify it. And he said, this is where the body is broken after the death, and there's a discoloration in the ribs here and there. And I said, could that be accounted for? And he said, that
Only guilty man in Shawshank.
moving the body. Said, correct. So Jeremy Townsend logically tells Laurie Shaver, I'll take care of this. She understands they got property elsewhere, logically. That body disappears at that time. Now, when did the body logically and arguably show up? When after that shooting, when Laurie said, it's over. It's over. Okay. She even took the stand, and I thought this was kind of sad listening to this. And after all the violence she incurred, she started crying and saying, I still loved Michael. So we know any relationship between these two was logically over. Now, maybe, and I don't know, we talk about flowers being sent, cards being sent. Was that sent by Laurie maybe to make sure Jeremy's not coming back? Maybe to get him in trouble with his wife? Possibly. You may interpret it that way. Now, we also heard from Mr. Cios, remember? And the state called him. It was their witness. And he said, I asked him this, didn't you call Laurie, advise her somebody was trespassing on your property? Yeah, she was gone, and I saw somebody trespassing. Who had any motive to come back to that property, deliver something back to that property if it had been removed? Jeremy. You see, that fits together a little tighter. Now, talking about that gravesite. Son of a bitch! Did the police think about the depth of the site, the height of Mr. Townsend versus Laurie Shaver? No. Never even analyzed that mentally. It's not that difficult to think about that.
Oh,
Okay.
that's why Dizzy was doing that.
Also, there's a
Oh my
blue
God.
tarp
Too much.
in the grave,
Too much.
right? We heard all about that. And I said this, and I don't know why this wasn't done. We had told the state about Jeremy Townsend. I said, did anybody do a financial audit of anybody's accounts to see who may have purchased a blue tarp? No. They should have. I'm telling you, if they had one on my client, they'd be in here waving it up in the air. It's her tarp. Lack of evidence, conflict in the evidence. I asked the officer as well. I said, did you guys, I said, you didn't find any prints on that tarp, did you? Now, I like the way the state tries to cover some of these lack of evidence up. Okay, I really kind of got entertained by it at a point. They'd say this, well, you weren't surprised, officer, that given the evidence was degraded that you couldn't find that, could you? No. And I'd say,
That's a good one. So Dizzy, every time I talk on mute, Dizzy, if you play the son of a bitch clip sound effect, I'll know. So that'll be perfect. Good job. I was laughing that Dizzy was playing a sound effect, not realizing that she was trying to let me know that once again I was speaking on mute. King of mute. Sting is the king of pain. I am the king of mute.
this, hey, what do you mean degraded? The evidence may have never been there in the first place. It could have been degraded when it went into the ground and evidence was put on it prior. How do you know the condition of the item before it went in the ground? But they had to acknowledge that, yeah. So the state would repeatedly,
That's
to try to
1.25.
cover up the lack of evidence, well, you're not surprised at this. It was all degraded. You wouldn't expect it to be there, would you? No. So that's how they try to defend themselves against the lack of evidence. We saw that repeatedly in this trial. Now, we heard with regards to the TARP, the state never investigated it. One. party with the burden of proof. 2, we heard Laurie and Isabel both take the stand. We didn't have one. We didn't have one. Now, that logically goes with the theory that that body had been off the ground, off that site, because it comes back to the property and it ends up in the gravesite. Can we assume that Mr. Townsend put that in there with the straps, wrapped it up, took it off-site, damaged the body, brings it back and puts it in the grave? That's a logical conclusion. I asked the investigator, I asked the tech people, listen, were there any telltale signs on that tarp that tarp had been dragged across the yard? Huh? What do you mean? I said, did you ask for any kind of chlorophyll testing underneath it to see if it had been dragged by somebody? No. You see? Do you know if Laurie took it out there? I don't know. Do you know the distance from the house? No, we don't. Somebody else can tell you that. So what does the state do? They offer some evidence showing she's working out, and you're just to jump to this conspiracy theory and say she could have dragged it out there. She could have done this. She might have done this for you to fill in the gaps that the state failed to investigate. And that's what we see in this evidence thrown in your face without a real connection. You look at the forensics. I brought out, state didn't do it. The defense brought it out. There's no DNA in the house, no evidence of how the crime occurred in the house, no prints, no hair analysis, yet there were hairs, okay? No match of any flooring that was found in the gravesite to implicate Laurie Shaver. Those all create a reasonable doubt. The state can't ignore it. Instead, they just want to say she lied about this or she lied about that and she's sleeping around. That's their case. That's the state's case. Now think about the gun we heard about. We have a gun in evidence. Again, kind of a comical display to me. You get this lady up there, and she goes through this litany as to her experience and everything. And she talks about, well, it has the signs of other guns, meaning this manufacturer that make Colt or Smith & Wesson that may manufacture a 38. They got a machine. It's going to have ridges in it. They all have that common characteristic. Millions of them, okay? But she can't identify any specific features of the gun. She can't narrow it down from millions to say it's this gun. Wow. Wow. So the state says it can't be excluded? No, it can't be excluded. Right. That's reliable evidence for you to hang your head on and to fill out a verdict for the state? No. The state's position is, well, we don't have to prove this case by 100%. No, they don't. Okay. That's not the requirement. We know what the requirement is. When Jeremy Townsend, the state was informed of Jeremy Townsend, why, ask yourself, didn't they look into his financial records? Lack of evidence. 2, why didn't they look into his Facebook?
I did think Jeremy was full of shit about a lot. One thing I did not think that Jeremy was full of shit about is that he didn't shoot Michael Shaver in the head. Didn't think he was lying about that. Thought he was full of shit about a lot of other stuff, though.
Aside from his banking. Do you remember what the testimony was on that by Tamara Dale? Here's what she said. Well, those records were too old. What do you mean they're too old? You're going to stand in here and tout that Laurie Shavers are reliable at the same period of time and not look into Jeremy Townsend, who you've been advised shot the guy? And not even look? Not even look anywhere into his matters? No. She was closer to the body. Okay. Now, let's talk about the patio. State thinks that's a big deal. I don't. Why? Because they cleaned it out to make a pond. We all know that. Okay. They get tired of building this pond, and it sits for a while. Concrete is bought. Now let's think about that. Nobody goes and tries to conceal themselves when they're buying any concrete. They don't go paying cash. They don't go in there with the hat on or anything like that, trying to disguise themselves. It's open and clear. They're not trying to conceal themselves. They go rent a mixer, not trying to conceal themselves, not trying to make it private, or a hidden event. They even post it on Facebook. Like this is a big secret? No. Who would do that if they're trying to hide a fact against the public and knowledge? You wouldn't do it that way. That's just
Oh, did you guys see GSD try to spell coinky dink? That's awesome.
common sense. Okay? You take the evidence and then you rely on your common sense or the lack of evidence thereof. That's the point. Who would write their name in concrete on top of a grave of somebody that they allegedly murdered? Not any person in the face of this earth would do such a thing. You got to admit that. So you see, there's another reasonable doubt the state can't account for. We had Holcomb, officer, take the stand and said, oh, it was right in the middle. Okay, like it was obviously trying to be concealed. It wasn't. When I pressed her on the video, she said, well, it wasn't on the middle actually. Then the next officer said, well, it was a darkened spot. And you look on the photos, well, there's about 3 or 4 darkened spots all over the place. Okay, doesn't mean, we know there's a body on there. There's clear evidence of guilt or anything like that. I want you to think about all those things that create a reasonable doubt. There's multiple, and the state can't excuse that. They cannot excuse those factors. There's a question, who killed, actually, Mr. Shaver? We know there's shrapnel. We know there's one fragment, but the shrapnel could have been a second shell. We know that from Shaw himself. Has the state eliminated self-defense? No. No, they haven't. Who has that burden exclusively and only? The state. We know this is a violent man who most likely didn't have a right to even be in the house. Is there evidence that the body was moved? Yes, there is. Has the state refuted that? No. Why no forensic audits? None. Now again, the state is looking for a verdict on something. Give me something. Give me something. So they got lessers, a primary, and an accessory. You have to understand, Laurie Shaver is not guilty. She's not guilty. Don't be pulled into an emotional game trying to compromise, thinking you're doing justice one way or another. You have to understand that. Laurie Shaver is not guilty of any crime. She has not committed a crime. The state has not refuted it through an investigation and presentation of evidence in this case. Again, I'll remind you with regard to the crime of accessory, it must first be established that a crime was committed. If there was a right to self-defense, no crime has been committed. You see? And there is anything that Laurie Shaver did was lawful. The state can't link up any transaction, unjustified or evidence of a cover-up if there is no crime that is committed.
He's rapping. Yeah, he just echoed what Green Ring said.
Likewise, the crime of accessory must establish a firm timeline as to when the crime occurred. You're not at liberty to say, well, the state says this and Laurie says this. Let's just pick a number. Could have happened between this date. The court will instruct you that that accessory requires the completion of one event before the start of an accessory offense. Okay? Has the state firmly established that? No. What they do is they say, well, there is, he didn't show up at work, so you got to assume that she murdered her. And then let's take the next step and say all this stuff was to aid or assist in concealing an offense versus living expenses and money that she had a right to touch and use. An accessory, when you see accessory, normally what you would see is somebody buying somebody a flight ticket to leave town, putting them in private housing, doing things to conceal them in that manner, not living like this. It kind of reminds me, this case, when I listen to it. It's all speculative, what you call circumstantial evidence. I'm sitting here listening, sitting at my table between approaching the bench, I guess, and listening to this, and I'm going, it's like playing a game of Jenga. Sooner or later, this thing's got to topple. You can't just keep putting little boards on top of each other without a firm foundation, you see? It's not going to stick. So the state just piles up some evidence and says, there you go. Come back here, reach us a verdict, okay? Give us what we want. Now, again, I remind you, and I'll sit down, leave it to you. The people that may have been misrepresented, the people that any lies or misstatements were given to, really are not relevant in this case. Laurie's not on trial for lying. She's on trial for murder. Any misstatement must have been to make and conceal a crime which never has occurred. You see, if she lied about Michael, where he was or what happened or where his tools were or where he'd been, is not really relevant in this matter. So don't be distracted in that regard. Going back to the digital data, I'll leave on this. Remember, I asked these witnesses, did you find anything in the digital data that announced or indicated somebody had shot anybody? No. Did you see any evidence in the digital data of any effort to conceal a crime? No. Could you tell me where this was coming from physically? No. Could you tell me who was using the device? No. So what did we have? I found it, I don't want to say it, but we get memes thrown in front of us and some emails from this place to that place. And you're supposed to say, let me hang my hat on this meme. Sometimes you got to burn a bridge and move on. That means Laurie Shaver killed somebody? And that's what the state is asking you to hang your hat on and just pile up a bunch of memes like a Jinko game? No. That's
Jenga.
not how you prove a criminal case.
Come on, bro.
With suspicion.
Jenga.
Bare innuendos without
Jenga.
physical evidence of guilt. Now you have, likewise, and I mentioned it to these people on cross. I said, you got a certificate over there, a business record certificate from Facebook, right?
Sidebar, please.
Oh my God, he was almost done. Sidebar, sidebar. Everybody hates a sidebar. Yeah. No, not licensed in NC. Just Pennsylvania and Illinois. The great state of Illinois. Yeah. Oh yeah. You missed the whole memes thing.
Business record certificates from Facebook. Really interesting. I brought it out on cross-examination. I mean, kind of floored by it. But here's what they say. In essence, read them yourselves. Well, we once had this data. We gave it to you earlier. We're sure we gave you something that was accurate, but we don't have the information anymore. So we got to just assume it was accurate. Okay? That's what the state's going to hang their hat on and say this digital data is even reliable for your consideration? That's not even digital data. And we know what Connor said. You can't even link it up from this place to this place because IP addresses have expired the physical location, and the state's hanging their hat on it to throw all this out there. Unbelievable. Further, the state doesn't even have a computer. There's no computer in this case. Not a computer for them to try to connect it to. I want you to think about these factors. This is where, ladies and gentlemen.
I mean, do I think it's 1.75 is pretty good with this guy. Do I think that it's convincing? No. But remember this, always remember this. We never know what a jury's going to do. And all it takes is one for a mistrial. Somebody on that jury could be like, dude is making all kinds of sense. We're all different. We all perceive shit differently. We all think about things differently. We all have our own lens that we look through things. Like, that's the beautiful and terrifying thing about trials is that jurors are human beings and we all feel and think differently about everything. So you never know. Never know. I think it's a big pile of steaming goo, personally, but that's me.
My power ends. This is where yours begins under our Constitution. I can only ask, I can only beg you to do your duty. Don't compromise your duty. I've listed to you multiple reasonable doubts in this case that should never be compromised by any single one of you. I asked each and every one of you as well to please hold your verdict, and if it disagrees with other ones on this full jury, that you please hold your ground. I've shown you everything, every way the state has failed in this cause. Don't be misled. I ask you. The state will have the last word in this case. They always do. Wasn't like that always when I practiced law, but it is. But as Mr. Coluccio speaks, I ask you to listen. Give him the due concern that you've given me. But I ask you to ask yourself as he speaks, what would Mr. Wiggs point to refute that? Have you answered Mr. Wiggs's questions? What about this question? What about the grave? What about the lack of evidence? What about the gun? Let's hear an answer to all these things. He can't give you an answer. So I ask that when you go back there, I know the answer, which should be given by you, but I can't do it. But I ask you to do the right thing and come back on all counts, all issues, and do justice, not seek a verdict for the state. Seek justice, as I ask. And return a verdict on all counts of not guilty. Thank you.
All right,
Thank you, Judge.
What would Mr. Wiggs do?
Thank you, Mr. Wiggs. At this time, I'd like to give the jurors a comfort break. We've been in
Oh,
for nearly
God.
2.5 hours, so let's take a 10-minute comfort break. Thank you.
Comfort break. All right, everyone. I want you to go back to the comfort room, pull out our comfort cots, lay your weary heads down, and listen to the soft elevator music that we've piped in from our courtroom elevator, playing all the yacht rock you could ever want to hear. It should be quite delightful. Enjoy.
Did we say that, Judge?
Yes, sir. So we're in recess for 10 minutes. Thank you.
All right, let's see what we got bloops wise. This is exciting. Bloop 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 bloop. No. All right, we're all blooped out. Well, we tried. What are you gonna do? We gave it the old college try, didn't we? So what do you think, kids? I think it's poll time. That's what I think. Let's go. Okay, now we still have the rebuttal closing, but yeah, it's gonna be more of the same. I think we feel whoa. Like I just went over to our chat and it's whipping through. You guys have been busy beavers, chatting away. All right. Okay, remember, this time it's still what you think, not what you think the jury's going to do. That will be the final poll. What you think the jury will do. Two different things. What you think and what you think the jury will do are two different things. All right. All right. Fire away, kids. Fire away. Let's see those votes. I want to see them pile up. We got 292 in chat. Let's break 200 on the poll. I mean, all you have to do is click a button, for God's sakes. Did he do it? Did he do it? Did she do it? She didn't do it. Did he do it? Should he do it? Did he do it? That's as fuck, Sheba. Sheba. That's the most adorable thing ever. Hey, thanks, Deja. Thank you. Comfort break. Everybody loves a comfort break. Yeah. Did he do it? Yeah. Let's see. We're overwhelming at this point. 85 votes. There's one holdout. One holdout. Whew. Show yourself, holdout. Raise your hand. Sheba. Sheba's the holdout. I like it. I like it. Sheba. Yes. Yeah, it's Laurie. She's on her phone. I'm innocent. I didn't do it. Oh, man. That is great. Oh, so good. You always need a holdout. You always need a holdout. But like I was saying, in reality, I mean, what would Mr. Wiggs do? I mean, all right. So Dizzy, it's obvious that we need I'm going to type it for you because that's how he pronounced it. We're going to need a Jenga emoji.
Are we saying this is a big game of Jenga? They're just gonna stack one thing on top of another? Bobby, this is a Jenga game, Bobby. Let's go play Jenga. Bobby, please don't be a clown.
All right. Yeah, it's a lot. Where are we at, Taylor? We are at the end of both the state's initial closing and the defense's closing, and now we're on a comfort break waiting for the rebuttal closing. So that's it. Oh, Sheba took a shot at Coinky Dink. 97% to 3%. That smells like Taylor. I think Taylor came in and voted not guilty. Like, that's the only thing that adds up. Taylor popped in. All of a sudden, it went from 99 to 1% to 97 to 3. Show yourself, Taylor. Did you vote not guilty? Guilty. Guilty. Well, we know. All right, but Sheba would have 2 E's. Sheba. Yes. Sheba would be Sheba. Can I get a witness on that? Somebody give me a witness. I feel, or am I wrong about that? See how Sheila spells Sheila? 2 E's? Or if I say sheesh, that's 2 E's. Is that how they spell it? Sheba? Wrong. Jeez, Joanne. No, I'm not punchy. I'm in a great mood. It's Friday. Going to see Goose tonight. Goose. Jam band music night at the Salt Shed. All right. I'm wrong. Yeah, maybe that's where C-Dub, maybe that's where I'm getting that from. Wasn't that the name of the trophy? That's probably been buried deep in my subconscious. Let's see. Oh, wait. Oh, yeah. There's also an Indian restaurant that I've eaten at called Sheba that spells it with 2 E's. Interesting. So if you pronounce Sheba, if you spell Sheeba, Sheba, how do you pronounce Sheeba? Inquiring minds want to know. Inquiring minds want to know. Let's go. Let me see the answers. Ooh, 96 to 4. Don't call it a comeback. I've been here for years. Mom said knock you out. Mama said knock you out. All right, good. Actually, it's way easier for Sheba because I have to like intentionally remind myself to say Sheba because I want to say Sheba. It just seems. Oh, let me see. The Queen of I get the reference. The Queen of Sheba. I just always thought it was spelled with 2 E's. A quick Google search has confirmed that I am incorrect. Once again, incorrect. You, sir, are incorrect. Incorrect, sir. Sheesh. Sheesh. Well, this is where I'm at on this case.
Only guilty man in Shawshank.
Yeah, that's it. That's where I'm at. Since I can't vote. I can't vote on my own channel. Some bullshit. That's what I have to say about that. That's all I have to say about that, as Forrest Gump would say. All right. It's got to be close. Let's go. Let's knock this trial out the park right now. Oh, let's see. I'm a little bit behind. Let's hit play. Still not at live. Oh, all right. There we go. Bloop, bloop, bloop. Oh, look at that. Telling secrets. No hot mic for us. Wiggs, I thought you were brilliant up there. Bloop, 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 bloop.
In concrete over the grave of their dead husband. Mr. Wiggs asked who would write their name in concrete.
All right, let me slow this dude. I'm not going to keep him at 175. I'll do him at 125, but we're going to catch up. So,
Concrete over the grave of their dead husband. A woman who killed her husband with ill will, evil intent, hatred, and spite, and then over a period of years covered that up with lies and manipulation against all the people that knew him. That is who writes their initials on top of that grave. And that is what happened in this case. Mr. Wiggs brought up numerous things. I'll try to address as many as possible, as quickly as possible. But some of the things he said, I ask that you go back and think about what's your memory of the evidence and the testimony and realize that that's just not the way it happened. One of the things he brought up was talking about how the state didn't bring you any things about how there was no DNA evidence in this case. I did. Edgar Perez from the Florida Department of Law Enforcement testified about the DNA analysis in this case. Who called it? Mr. Wiggs? From state. We presented that to you. We presented you the fact that what the DNA evidence was, and the fact that it's not that it was someone else's DNA and we can't match it up. There's just not enough genetic material in anything that was in that gravesite to compare it to anyone. But that came from the state. And Mr. Wiggs got up here and talked to you and said that he was the one that brought that up. And that's not true. It just goes back to you can't trust the little things. How can you trust the big things? He talks about.
And how can you trust a lawyer that calls the great game of Jenga jinky? Or whatever he called it, Jenga.
What he refers to as shrapnel in the skull, and how that's evidence of potential 2 bullets. That's what Dr. Shaw told you. That's not what Dr. Shaw or Dr. Coverley told you. They said that shrapnel is not evidence of a second bullet, but when there is gunshots like that, typically there will be small metal fragments from the bullet. There's only one entry wound. There's no exit wounds, and there's one projectile. There's no second bullet. There's no second shot.
Finally. Jesus
Talks
Christ.
about how the state has presented no evidence to refute self-defense. The state has presented undeniable evidence that Michael Shaver has been dead since November of 2015. And if he is dead in 2015, he can't possibly be on the Shaver porch sometime in May in 2016 and have the events that were relayed to you happen. That's how we've proven to you beyond a reasonable doubt that this wasn't self-defense, because we've proven to you beyond a reasonable doubt that he has been dead since November of 2015. And if he's been dead since November 2015, Jeremy Townsend had nothing to do with it, because that relationship had just started at that point, continued up until April of 2016 when the affair was exposed, and then it was over. Laurie Shaver can tell you what day she kicked her husband out of the home in November of 2015, but cannot tell you the day he died. Think about that. Isabel can't even tell you what month or what year, but Joy says she's a kid. That's not a big deal. Laurie Shaver cannot tell you the day her husband was killed on her front porch. That is completely untrue. And the only reason for that is because she's afraid I'm going to find something in some of these records to completely refute it.
Oh,
So if she tries to keep it vague,
exciting.
that's harder to do. But Michael Shaver has been dead since November. And if he's dead in November, the way Isabel and Laurie described these events to you could not have happened. And therefore, it's not self-defense or defense of others.
Hey, Jenko.
Once again,
Oh, what a day.
talking about Isabel and her inability to even remotely tell you when this happened. Mr. Wiggs says that I just completely made up this summer time frame. I asked you to go back, think about her testimony, look at
Thanks,
her notes.
Diz. Yeah.
When I went through and I asked her, can you tell me what grade you were in? No. Can you tell me what year it was? No. Can you tell me if it was around a holiday? No. The best she could do is say that we went to the beach, so it was sometime between spring and summer. And then I asked her, what spring is to you and what summer is to you might be different to me. So what is spring to you? And she said April. I said, what is summer? End of summer. And she said that would be before school, August. That was her testimony. But to rely on your own memory of those issues. Briefly talking about accessory after the fact. And the reason I say briefly is because the state has presented to you evidence beyond reasonable doubt
Jenga?
that she is in fact the
We're
murderer
gonna
in this
play
case
some Jenga?
because her husband was killed in November of 2015. The evidence, the story, with all of its holes that the defense has been presented to you, if you were to believe that and ignore all the evidence and just ignore the facts that Mike was completely disappeared off the face of the earth for 6 months without a car, without a job, without a bank, without a phone, without any contact from friends, family, coworkers for 6 months and showed up without a vehicle, dressed in shorts and socks, and this event happened in May. The events as described to you by the defense show that she's guilty of accessory after the fact. Even if the initial shot by Isabel was in defense of others, according to them, when Jeremy Townsend comes up and shoots again, coup de grace, puts him out, kills him for sure. That's not self-defense or defense of others anymore, folks. That's murder. And when Laurie lies, manipulates, and covers up the fact that her husband has been dead for years, that's maintaining, assisting, and another person to conceal evidence of this crime. The defense's story is that she's guilty of accessory after the fact. The evidence in this case is that she's guilty of second-degree murder. And as I told you, the law says you can't be an accessory to your own crime. One of the things that I think is very important, one of the details that also undermines their whole disappearing body story, is Laurie's actions when law enforcement comes and excavates the gravesite. First and foremost, their story is somehow in that short drive back and forth to Pine Ridge School, Jeremy somehow got the body out, cleaned it up. They speculate maybe he drove a couple hours to Crystal River to hide the body up at his parents' house for a while, only to return at some other point to bury the body unbeknownst to Laurie Shaver in the backyard. She never notices any, like, oh my gosh, why is there upturned dirt here? And then returns the body, buries it without her knowledge, and of the entire 5-acre plot, she just so happens to choose that to put a cement slab down. That's completely unreasonable. But she needs to say that in order to convince you that she didn't know the body was there. But you have evidence that absolutely refutes that. Because Jessica Wade testified that they were doing this search and this excavation. And Laurie sat in her truck and was sitting there the whole day, the whole time watching. When did she leave? When law enforcement started to pull up that concrete over the body of her dead husband that she murdered. Law enforcement, when they were done, the process, when they were done, search, took a couple of days. Detective Strickland called her. Said, Laurie Shaver, we are done all our work. You are allowed to come back to your property. Would you like to know what we took from the property? And she said yes. And he went through and proceeded to tell her everything that they took. We took some swabs, we found some projectiles, we took some other items from inside the house. We took skeletal remains from your backyard. And this woman who is sitting here trying to convince you she had absolutely no idea that her dead husband was buried under the cement slab that she poured or helped pour, had no reaction whatsoever. That's why we played that call. That's why we had that for you to listen to. So you could see just how she reacted when told there was a dead body in her backyard. Nothing. Because she knew it was there. She absolutely knew that. The defense has talked about how law enforcement, how their investigation, and they didn't look into self-defense. They didn't look into this story. And despite the fact that Kelly Johnson sat up there and told you, yes, the state was asking me repeatedly if I was going to produce my client, yet I did not do so until they issued a subpoena to her for deposition, thereby giving her immunity, I wasn't going to allow her to talk to them. But he wants to put the blame for not looking into her on me? When the witness he called said I was the one preventing it because I was doing my job as an attorney, and he sits up here and tells you that's me not looking into it? That's just not true. And it's not true based on the evidence he presented. He also talks about, in this, has the state eliminated self-defense? And it always is going to come back to the evidence shows you that Mike Shaver was dead since November of 2015. And that is overall how the state has proven to you it's not self-defense, defense of others, because that story in May can't happen if he's dead in November. But also think about whether or not their story is even reasonable in this situation. The scenario as outlined by Isabel and Laurie happens. What reasonable person is not calling 911 to let them know? I'm not saying do it in front of Jeremy under this scenario that they've outlined, but go some other place, call 911, explain what happens. The idea that Jeremy comes in, sees Mike Shaver shot, and then in that scenario decides he's going to shoot him again and move this body to different parts of the state and come back, that makes no sense whatsoever. And there's no evidence of it at all. He points to the neighbor, Robert Seha, saying, well, I saw a trespasser one night. Well, fine. Did that person have anything? Were they doing anything? I mean, I didn't really see. Do you really even know if they were a trespasser? Not really. But most importantly, he says that happened in 2018. The cement slab is poured in 2016. The body is already there under. That trespasser has nothing to do with this. The timeline doesn't work. Also, Rebecca was living at the house at the time frame this happened. She says, I moved in there in May. While I was there, Jeremy came over to visit. When? At lunchtime, when Laurie was on her break. Exactly the way Jeremy described when he would come. Not 3 to 4 overnight visits, which would obviously put his wife on notice that something was going on, which makes absolutely no sense. But Rebecca said that she had moved in. Jeremy would come over during lunch, as Jeremy said that, but Rebecca was living there during this time frame. This didn't happen the way Laurie and Isabel said. In talking about the 2014 incident, Mr. Wiggs talks about how he went after Wilma Nicholas, and he pointed out that, well, the state prosecuted her or him, and you only got one side of the story. But that completely ignores the fact that Katina Vasquez, Laurie's friend, came in and said, you know what? Laurie told me she fabricated that. That's not the way it happened. She was the aggressor. She threw that flower vase and broke the slide glass door. She hit her husband over the head. And when Mike was saying that he was trying to basically grab her, to control her, to stop her from doing these things, that was true. That's her friend saying that. The timeline. Once again, go back to those phone records that establish that Mike Shaver's phone, the phone number that he originally had, changed 2 times, ultimately ending with a phone number that Laurie Shaver admits is hers, puts in a court filing is hers, showing you that she had that device the whole time. They want to insinuate maybe Jeremy Townsend said some of these messages from Facebook. Well, we know he's not sending the 500 pages to his wife to expose the affair. That's not him. Who had motive to do that? Her. We know he's not sending this message in September 20th, 2016, months after the relationship between him and Laurie is over and he's back with his wife, saying, hi, Vanessa, how are you? Moving on looks good on you. Hope you and your son are doing well. After we know Michael Shaver is underneath the cement slab, we know Jeremy Townsend has no reason to send his wife that message. All of this connects back to Laurie, and all of it connects back to her and her attempts to cover up the crime that she committed, the murder. Mr. Wiggs, as he was going through, kind of picked and chose some things here about the heat of passion defense, and just kind of threw out some buzzwords like digital data he's been doing all week. But when he's picking and choosing through the excusable homicide heat of passion, you can't just pick some choice phrases out. You have to read it as a whole. And as you see, none of this, even under the May 2016 story that has no factual support whatsoever, would apply to this situation. The defense under the May 2016 version of events, which is completely refuted by the evidence, would be defense of others. That's Mr. Wiggs talks about how there's been no investigation into whether or not there was drag marks or chlorophyll testing. That's fake CSI TV stuff, folks. There's been no testimony whether or not that test even exists. Quite frankly, I've never even heard of that. He talks about Richard Connor and the long credentials of Mr. Connor and Corporal Strickland. He's just a corporal. He's just law enforcement. He doesn't even know what he's talking about. What did Corporal Strickland and Richard Connor say that conflicted each other? Nothing. Absolutely nothing. They both told you an IP address is something that is given to you by an internet service provider, and it's assigned a location. It's basically like a physical address. That is what people will use in order to hook up their devices to the internet. They both said that. Richard Connor acknowledges that the Facebook records and the IP logs within them are the types of things that he, as an expert, relies on all the time. Richard Connor told you that those Facebook records that Mr. Wiggs wants to say are unreliable were reliable. He says that the fact that 2 different accounts are accessing the same IP address and close in time is consistent with them being in the same location. knowing what that physical address is would be nice, but it is not at all necessary when you look at 2 years worth of IP addresses showing multiple times these two devices are accessing the same IP address. Where she was using both of these devices doesn't matter. The fact she was utilizing the same IP address shows that it's someone in the close proximity and the same person. That's what Richard Connor said, and that's what Corporal Strickland said. I've got a few more messages to demonstrate how this had nothing to do with Jeremy, and quite frankly, nothing to do with Michael Shaver, who's been dead since November. Mike Shaver has absolutely no reason for Vanessa and Jeremy to get a divorce. Laurie Shaver, posing as Michael Shaver on April 18th, says, "I'm sorry, Vanessa, you must be running scared. I heard JJ Gall is a good divorce attorney." Who stands to benefit? She does. Mike Shaver, who's been dead now for about 5 months, stands nothing to gain from the divorce between Vanessa and Jeremy. Laurie does. We've already discussed the September 20th, after the slab has been poured. Makes no sense for Jeremy to have sent that message, but that is the "Hi Vanessa, how are you? Moving on, looks good on you." This last message, I ask you, is this a message sent by a man trying to inform another woman that his husband is cheating on him? Or is this the message of a woman trying to drive a wedge and get a divorce so she can get the man she wants? This is April 20th, 2016. "Hello, Vanessa. How are you doing? I know you asked for no more information." Right there. Vanessa said, I know there's this affair. You don't need to give me anything more. I got it. But I feel you should be aware of this. There are emails from October through November I have been reading. There is one from November 3rd where she asks him if he changed the sheets. He replied, no, that he had not. Loved being able to smell her and that he would inform you the spot was from him if you noticed. It appears she has been at the house and they have had sex in your bed. Thought you should know that. It also appears he invited her to stop by at your Halloween party, but she declined, not feeling comfortable with you being there. Pictures of that night were sent as well. There's a ton more information about how they met, what transpired. If you would like a copy of email logs, let me know. Vanessa tells him, I got it, I understand. They're having this affair. You don't need to give me any more information. But Laurie says, you know I had sex with your husband in your bed, right? Who would do that? Mike Shaver? Jeremy Townsend? Chinese hacker? Laurie Shaver. Mr. Wiggs got up here and said, the state just wants you to be mad and check off guilty of second-degree murder because the state's proven to you that she had some affairs. And he said, specifically, why do we have to hear that evidence? We had to hear that evidence because these are the two individuals that he provided to law enforcement. When Laurie was first arrested, he said, you need to look into Jeremy Townsend and James Ballou. And how are they connected to Laurie Shaver in this case? They were having affairs with her. This all came to light because Mr. Wiggs told law enforcement investigate these people. And they did. They did. Jeremy Townsend talked to law enforcement 3 separate times. Came in for his deposition. Came in, told you what was going on. And his testimony is consistent with the testimony of other people that he has no relationship with, that he has no connection to. Rebecca Urbanowski, who was friends with Laurie, states that Jeremy would come over during the day when she was on lunch break and wouldn't spend the night. That's what Jeremy said. Isabel and Laurie said he would spend the night 3 to 4 times a week. That's not consistent because it's not true. Oh, minor point, but this is just another example of how I think it's very important for you to rely on your own memory about testimony. Mr. Wiggs talked about Jessica Holcomb and how he says, she said this body was found in the middle of the fire pit. He was very insistent about that. He said, remember that video that was played. Please remember that video that was played. Because he confronted her on cross-examination. Didn't you say it was in the middle of the fire pit? No. Well, where was it then? And she sat there without missing a beat. That fire pit looks like, from top down, looks like the continent of Africa. And if you were to go into the bottom section of it and the point facing at the house, and you were to go right under there, under where the depression was, that is where the body was found. That's what she said. Not what Mr. Wiggs said. The state has proven second-degree murder beyond all reasonable doubt because of all the evidence points that Michael Shaver, as Laurie said, is not a missing person. He's no longer walking the face of the earth. And he has been that way since before November 10th of 2015, when all indications of him and his life are gone. No bank activity, no phone activity, no contact with family, no contact with friends, no contact with work. Wasn't at the hangar where she said, wasn't in Georgia where she said. He's dead because she killed him. And then she made up this May 2016 story to distract. That's pure and simple what we have. If there is absolutely no evidence consistent with that May 2016 story, ask yourself why. And it's because she killed him in November. And because of that, she's guilty of second-degree murder with a firearm. I ask that you return the only verdict consistent with the law, the evidence, and justice, and that is guilty of second-degree murder with a firearm. She possessed that firearm. She discharged that firearm, and she caused great bodily harm or death. Thank you.
All right, thank you. Members of the jury, I thank you for your attention during this trial. Please pay attention to these additional instructions I'm about to give you. Rules for deliberation. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. In this case, all of us are depending upon you to make a wise and legal decision in this matter. Number 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not. In accord with the law, it is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be reached as to each crime charged. The verdict must be in writing, and for convenience, the necessary verdict forms have been prepared for you. They are as follows. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01, verdict, count 1. We, the jury, find as follows as to count 1 of the charge. In parentheses, it indicates check only 1 as to this count. And there are A, B, and C. A, the defendant is guilty of second-degree murder. In parentheses, it states, if you checked A, please answer the following questions. Number 1, was the defendant in actual possession of a firearm? Yes or no. Number 2, did the defendant discharge a firearm? Yes or no. Number 3, did the discharge cause great bodily harm? Yes or no. In section B, it states the defendant is guilty of manslaughter, a lesser included offense. In parentheses, if you checked B, please answer the following question. Number 1, during the commission of the manslaughter, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no. And C, the defendant is not guilty. So say we all, dated this blank day of September 2024, and there's a signature line for the foreperson. Verdict form, count 2. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01. We, the jury, find as follows as to count 2 of the charge. In parentheses, it states check only 1 as to this count. There are options A, B, and C. A states the defendant is guilty of accessory after the fact to second-degree murder. B states the defendant is guilty of accessory after the fact to manslaughter. In parentheses, if you check B, please answer the following question. Number 1, during the commission of the manslaughter, did the person who committed the manslaughter personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no. And for option C, that states the defendant is not guilty. So say we all, dated this blank day of September 2024, and again, there's a signature line for the foreperson. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over the deliberations. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, or electronic communication, such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Certain exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibit, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, at this time, I will excuse the 2 alternate jurors, Ms. Davis and Ms. Hernandez-Urbina. You are the alternate jurors. You are excused from further service. Thank you for your time and attention.
All right. Let's go. Let's go. All right, just so you all know, I've set up a live with like a random time, like 9 o'clock. If they come back with a verdict, Dizzy hopefully can hop on because I'm going to be at a concert. So I'll keep an eye on my phone if they happen to come back.
You may be seated.
But hopefully we'll find out here how long he's going to be willing to go tonight. Did they just say the jurors' names? Oh, jeez. Oh, boy. Yeah, there's supposed to be anonymity.
All right, then. Is there anything further before the jurors go back to deliberate?
No, sir.
All right, please bring the jurors back to deliberate. Thank you.
All right, it's in the jury's hands. I'm going to put the over-under at 3 hours. That's what I'm going to put it. I think there's bound to be one juror who's going to ask the question, what would Mr. Wiggs do?
All right, the jurors have gone back to deliberate. Anyone have a clean copy of the jury instructions?
I can print one up.
If you would, thank you.
Yes, sir.
Seatbelts attached.
Do the parties wish to review the evidence before it goes back?
425
That's fine.
in Florida.
Go ahead. I'm just finding the final jury instructions to send the task.
Yes, sir. Thank you.
Oh, thank you so much, Michelle J. Appreciate you.
Maybe
Gifting
seated.
5DD membership.
I
Thank you, Chuck. Sure appreciate that.
Jury instructions and verdict form to the clerk, so when she's done.
Thank
Mr. Buckland.
Mr. Wiggs, if you could review the final copy before it goes back to the jury to make sure it's to your satisfaction.
This is the latest one, Mr. Buxman, that I'm sure.
Whoa, Dizzy found a verdict clock. What a hero.
It's a French
What a hero.
All right, thank you, Madam Clerk. All of this. I think, Madam Clerk just received the verdict forms. If you could send.
I'm sorry.
Yes,
Oh, never mind.
Thank you.
yes, sir.
Could have just kept it with you, Diz. I never would have known.
Eric, some requests that they're writing down. I told them to write it down.
Oh, then you put up a verdict clock and I'm gonna go play some Jenga.
No, not that. I know one is the one to use a whiteboard.
Oh, alive.
No, not that. I know one is the one to use a whiteboard.
All right, they're just working through some shit. So I'll keep it up on mute though. I don't want to hear that horrific buzzing anymore. All right, y'all. So that's it. I don't, it's yeah, there's life. There is a potential for life on the second degree murder. There's a pretty big range that the judge can go. I mean, if they find her guilty, I imagine this judge is going to hammer her, considering that she hung her daughter out to dry. So we'll see how it plays out. I would not be surprised if this thing goes. It's always an X factor on a Friday when they go to deliberate. You worry about it as attorneys. You're like, oh man, I hate when they start deliberations on a Friday, because if they're like, oh my God, I don't want to, we're not dragging this thing till Monday. There's no way I'm coming back here. It's always a concern floating through our minds. So, all right, I'm going to wrap it. Like I said, I did create a live for later. If we do get a verdict, I'm hoping, if I'm not available, that Diz can get it fired up for us. Obviously I won't be able to comment on it, if it is while I'm at Goose. But I'm going to a show. That's it. So I can't be stopped. Cannot be stopped. You guys have been amazing. Thank you so much to my mods. All of you have been wonderful all day, as you always are. I couldn't do it without you guys. And thank you for all the generosity in chat today. It's greatly appreciated, more than you know. It means the world to me, and it really helps Allie and I financially, because I'm not practicing law anymore. So I left the practice. We were officially a one income family. So we rely on it. We really do. So, and it means a ton to us. We really, really appreciate it. And we think we earn it. So we appreciate that you feel the same way, and you show it by sending us little generous love notes with a little cash attached to it. So, all right, you guys, I want everyone to have an amazing weekend. I want you guys to all take care of yourselves, take care of your loved ones, enjoy yourselves, sleep in, rest, relax, rejuvenate. Just think about comfort breaks the whole time, the whole weekend. I just want comfort breaks running through your mind. Think about comfort breaks. All right, you guys are the best. All right, chat. Best damn chat in the land. You guys, once again, crush this trial. No better place to hang than here. And I will die on that hill. You guys are the best. Thank you, because without you, just an old man talking about a whole bunch of cases. Thanks, y'all. Love you.